number 1. All right.
Next week on date, some file ಮಾಡಿ twice I have moved the matter.
ಯಾವುದು?
ಒಂದು DE matter, ಒಂದು promotion, ಒಂದು recovery.
ಅಷ್ಟು ನಿಮ್ದು ಒಂದೇ ತಗೊಂಡು ಉಳಿದಂತಲ್ಲ
ಅಲ್ಲ.
ಯಾವ್ದಾರು ಒಂದು ಕೊಡಿ.
Next week any date, sir.
Huh?
Next week any date.
Next week difficult. We are in the mid of framing important judgments, having some far-reaching consequences. That's the reason.
Yeah, ಒಂದು date.
After vacation.
Lordship's transfer matter, the only urgency is I'm prematurely disturbed without any posting and tribunal denies to give entry model lordship. Only insofar as non-grant of entry model by tribunal. Can request it for tomorrow, day after tomorrow.
Third, ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
One,
ನಾಳೆ ನಾಡ್ದು ಯಾವ್ದಾದ್ರು ಹಾಕೊಳ್ಳಿ.
I'm great.
one matter, my lords, lordship had heard and reserved. This is probate matter, my lords, order 7, rule 11. My
We are
submission,
pronouncing judgment tomorrow, perhaps.
How?
Lords,
oblige.
I'm for the respondents in this case, my lord.
Ah.
We'll file by afternoon.
If you want to file, see, we told you, we'll vote ಅಂತ. ಏನಾಗ್ತದೆ ನಾವು ಮರ್ತು ಬಿಡ್ತೇವೆ ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ. ಆ ಕಾರಣಕ್ಕೆ ನಾವು ಹೇಳಿದ್ವಿ, ನೀವು ಇದನ್ನ ಮಾಡಿಲ್ಲ. ಏನು ಕೊಡದಿದ್ರೆ ಇವತ್ತು ಕೊಡಿ. Because tomorrow, day after, we are pronouncing the judgment. One finer aspect, both it did not argue. Section 14, you did not argue at all of the Limitation Act. ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿ? 14 ಅನ್ನು ಯಾರು ಆರ್ಗ್ಯೂನೇ ಮಾಡಲಿ? Myself and my brother discussed about. 14 was never argued before us, never argued before the learned single judge also. Discount argue ಮಾಡೋದು ಬೇಡ. ಅದಕ್ಕೆ ನಾವು ಯಾಕೆ why I say all books prescribed for law course, 18 books should be read by all lawyers. They are very important. ಈ ರೀತಿ ಮಿಸ್ ಆಗ್ತದೆ. Anyway, ನಾವು ಕಣ್ಮುಚ್ಚೊಳಗೆ ಬರಲ್ಲ. Material on facts ಮೇಲೆ ರೆಕಾರ್ಡ್ ಮೇಲೆ ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. Anyway, all.
My lord, in this appeal, my lord, the appellant has pledged the shares of his company to obtain a stay of my decree, my lord. Now they are alienating the assets of the company, my lord. There's an IA for injunction.
Yeah. They are alienating the property.
Yes, my lord.
Mr. ESG, I have to say sorry to you. What you argued was 100% correct.
I'm grateful.
I was 100% wrong.
I'm grateful.
No, really, tell you. You went a little disturbed from my court. That again disturbed us. It should not happen to a lawyer of your repute.
After all, dispensation of justice is.
But what you argued, what he argued is 100% correct. And I was 100% wrong. Just we sat and we discussed that. And we'd have laid down very, very wrong law. There are 14,000, about 3,000, 13,000 odd railway engines in the country. For each railway engine, there are 4 drivers. That will be about 52,000 drivers. Number 1. Number 2, this will apply to rest of the people also. This is what he was highlighting. Somehow I feel I owe apology to you.
I'm grateful. I'm grateful.
We are recalling that. Let it go before some other judge, because you should, both of you may not think that we want to hold to our opinion or something like that. Let it go before
Very well.
any, or we'll call it after vacation. Let
Very
us
well.
see what's-
Because only one submission, Lord. It might be a different cadre, but
Ah.
for the purpose of, they have introduced the fast track scheme.
After learned ESG, is a tall advocate, you are also. But after again, we thought, and he was disturbed because we were wrong in our approach to the court. He was saying, you said that appointment is same, training is same. He said, you are going by his version, you are not giving me 1 day opportunity. Why are you making that haste? He asked the other day. He was more than justified in asking us. And then we turned every page. In fact, Saturday went only for that. Friday, Saturday went only for that. I could not read other books at all, which I never go to bed without reading other books. But 2 days I did not read anything.
Since
I read he was 100% correct. Yeah, I'm sorry.
I'm
That in fact, what you said was 100% correct. While framing this judgment, we entertained a huge doubt about our own view, and therefore we posted this matter for being spoken to suo motu. First off, the order dated where so and so, whereby writ petition was disposed of, is recalled. First off, and the matter is restored to the board for consideration afresh. All right. I'm sorry, we were wrong.
I'm grateful.
Rejecting your contention.
I'm grateful.
And we saw that we were disturbed that day because it appears that way. Because
The natural
consequences,
procedure.
all right.
Yes, sir. I'm grateful.
Ramification,
I'm
which he was highlighting. Yes.
Because that should not be a point of consideration because my lord, the
We'll
feeder
we'll
cadre
come to
being.
that one. We'll come to that. Now we have made.
Great.
He said some sensible thing. Somehow our mind that day, my mind.
Because since
I
all
will
the
not say
three
my brother.
separate.
My
posts-
brother said, he said, no, it appears we have to reconsider that. In fact, see, we can't, now RET, num particular view, narcissically we cannot hold on to our view. That will be narcissism, which court should not do. Dixit can do, Mr. Joshi can do, not Justice Dixit and not Justice Joshi. No, we can't do that.
But,
Very sorry. Yeah.
Article 51AH, which is a fundamental duty. It requires all the citizens to develop scientific temper. This is scientific temper, where the mind is open.
We have
That
to.
when it is proved that turns wrong, that you are willing to
But we
accept
should
it.
say that. Otherwise, the grandeur of the institution will go.
True.
It is not that we are all Hellsberries here. We are bound to commit mistakes.
The similar interpretation has been laid down by other high courts as well. It's not like completely wrong.
Your interpretation is rejected by
Well,
Gujarat High Court, which perhaps learned CG, ACSG was not briefed because it is identical matter. It goes against you. Sorry, we have made research on our own. Which is that way, that Gujarat Ahmedabad bench. Share a copy with both of them. There are some trappings in relation to that one. Therefore, just look into that also.
I'm
We are
grateful.
sorry that we
I'm
heard the
grateful.
other day. Yes, I'm sorry, not he. My brother was silent. No, no. Yes, yes, all recalled. Okay. Ah.
That case, my lord,
Yes.
certain CS are filed, my lord.
Huh?
Company applications are, 4 applications are filed by the other side.
Yes.
That served a copies to me.
ಅದಕ್ಕೆ ಅವ್ನು ನೋಡ್ಕೊಳ್ಳಿ ಆರ್ಗ್ಯೂ ಮಾಡಿ ನಾವು ಟೈಮ್ ಕೊಡಲ್ಲ ಒತ್ತು 3-4 ಸರಿಯಾಗಿದೆ ಈಗ ಯುವರ್ ಫ್ರೆಂಡ್ಸ್ ಕ್ಯಾನ್ ಗೋ ಫಾರ್ ಎ ಸ್ಮಾಲ್ ರೌಂಡ್ ಸರ್ ಶಂಕರ್ ಸರ್ ಇಫ್ ಯು ಪರ್ಮಿಟ್ ದಮ್ ದೇ ವಿಲ್ ಗೋ ಫಾರ್ ಎ ಸ್ಮಾಲ್ ಕಾಫಿ ರೌಂಡ್ ಯುವರ್ ಫ್ರೆಂಡ್ಸ್ ಬಿಹೈಂಡ್
Not on this side.
ನಾಟ್ ದಿಸ್ ಸೈಡ್ ಸ್ವಲ್ಪ ಆಗ್ಬೋದು ಟೈಮ್ ಆಗ್ಬೋದು at least coffee round you can go. Yeah. It appears that way. Yes. On the next in line, immediately next in line, on the 2-3 jana ideve. For any reason it breaks down.
Correct.
Then we have to take up, we have to other matters we have to take up, na? Yes.
The assurance is the presence of Mr. The fairest man.
Huh.
The assurance like for all of us is a man who knows his responsibilities before the honorable court. Please, madam.
Yes, sir.
Let Mr. Subbarao handled this matter before the learned single judge and before this honorable court. Too.
Yes, sir.
The legend in labor jurisprudence.
Of course.
Therefore,
Boss.
what I may attempt at putting across an argument which he had conceived, I may not be 100%.
ಫುಲ್ ವಾಯ್ಸ್ ಹೆಂಗ್ ಜೋರ್ ಬರ್ಬೇಕು ನಮ್ಮ ಶಂಕರ್ ಸರ್ ಹಂಗ್ ಬರ್ತಾ ಇಲ್ಲ ಅದೇನ್ ಕೇಸ್ ವೀಕ್ ಇರ್ಲಿ ಬಿಡ್ಲಿ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಏನ್ ಸಂಬಂಧ ಎಸ್
I beg to borrow his synopsis in page 2 of this appeal memorandum. It's unusual for Mr. Subbarao to put it in one sentence. OSA 8 of by Shrishma Employees Union. ಸರಿಯಾ?
ಎಸ್
ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ನಮ್ಮ ವಾಯ್ಸ್ ಹೆಂಗಿದೆ ನೋಡಿ ಹಂಗ ಬರ್ತಾ ಇಲ್ಲ ಎಸ್
Permit me to say
Yes,
in
yes, yes.
1981, company was incorporated as a private company as Shrishma Chemicals and Pharmaceuticals Private Limited. 83, manufacturing operation commenced after the workmen were appointed. In 83, company changed its name as Shrishma Fine Chemicals and Pharmaceuticals Karnataka Private Limited. 83, Shrishma Chemicals became a public limited company. Perhaps this is one point which has some meaning in its application. It became a public limited company.
ಇಟ್ ಬಿಕೇಮ್ ಎ ಪಬ್ಲಿಕ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿ ವಿತ್ ಇಫೆಕ್ಟ್ ಫ್ರಮ್ ವಿಚ್ ಡೇಟ್
At 24/3/1983,
ಯಾವ ಸಿನಾಪ್ಸಿಸ್ ಓದ್ತಾ ಇದ್ದಾರೆ ಅವರು
main activities my lord, your lordship now will notice the next. What is the business this company was expected to do? Main act.
ನಿಮ್ಮಲ್ಲಿ ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆ ಏನೋ ಸಿನಾಪ್ಸಿಸ್
I'm reading from the memorandum of appeal.
ಮೆಮೊರಾಂಡಮ್ ಆಫ್
Memorandum of appeal. No, I said, sir, my lord, I can't make my contribution without referring to what Mr. Subrao had in his perception.
ದಟ್ ಈಸ್ ನೋಟ್ಸ್ ಆಫ್ ಸಬ್ಮಿಷನ್ಸ್ ಅಂತ
ಇಲ್ಲ,
begin
ಅದು
ಆಗತ್ತೇನೋ?
ಅದು ನಂತರ perhaps. This is presented on 16/5/2016.
ಹಾ ಈಸಿ ಆಗುತ್ತೆ ಸ್ವಲ್ಪ ಆಮೇಲೆ ಕಟ್ಬಿಡ್ಬೇಕಾರೆ ಎನಿವೆ ಎಸ್ ಸರ್
My lord,
ಕಂಪನಿ 24/7/81 incorporation
incorporates a private limited company by that name.
ಎಸ್
83, it commences with the work after the workmen were appointed. In 83, company changed its name as Shrishma. These are all not very material. Next is on Shrishma 24 through 83, it became a public limited company. Then what are its activities is explained next. Main activities of the company were manufacturing, selling, buying, and export of import of pharmaceuticals and chemicals.
ಎನಿಥಿಂಗ್ ರೆಲೆವೆಂಟ್ ಇನ್ ದಿಸ್
My lord,
activity anything to nothing?
No, I'm only trying to say that they have not even produced one pill so far. The activity, it was the ultimate analysis is this. They took an industrial land from KDC, this okay, what is it called? Karnataka Development.
Industrial area development.
Industrial area development. And they waited for an opportunity to have a problem situation which enables them to sell. The ultimate thing is they have sold the land without, contrary to the scheme, contrary to law. This is what I'm trying to submit. Well, please, well, next is main activities, register of, kindly go to 2/1/1992. Workmen were refused by employment by the company. The labor issue started. Workmen were refused to be employed by the company, 92. The management illegally refused employment to the appellants in the guise of lockout. The workmen challenged the lockout by raising a dispute in 10 of 1992. Karnataka State Pollution Control Board initiated proceedings as the industry was discharging of effluents. The subject matter was soiled. Then directions. Kindly come back
You
to.
said till date they have not produced anything. How that affluent will be generated if a factory is not working?
Well, perhaps very in a very simple manner will be explained. First, we'll have this
All
in mind. This is the background information to the Honorable Court to make the next 2-3 submissions. But I would be brief. But event is 27/4/94. The change of management. Notice were issued to the workman by the company informing transfer of undertaking. Then this Honorable Court held transfer of shares does not amount to transfer of undertaking. There is no change in the management. Which is against me. I am pointing out at this stage itself. On 24/6/94, the workman petition, which was pending in the file of the Honorable Court, came to be disposed of as per order. The Honorable Court recorded a clear finding that the transfer of shares does not amount to transfer of undertaking. WB came to be disposed of on 24/10. This has some relevance in the submission which will be made in 10 to 15 minutes. Then we have kindly come down to the page 5. Page 5, bottom 6th item, 20/6, order of the AIFR appeal came to be dismissed by. Then Balpharma was directed by the AIFR make out a case before the High Court. Company petition 88/2006 was registered in the register by BAFR. Order of winding up was passed by the Honorable Court. This is 27/7/2006. This is the next relevant fact. Winding up was ordered. OSA 35/26 came to be filed by the appellants. CA 927 was filed to explore a scheme for revival of the company. IA 3/2000 was filed for investigating the affairs of the company in the OSA by the appellant. OSA 35 came to be allowed. The division bench further ordered IA 3/2000 that CA 927 be listed before the company judge. Then company application came to be filed by SDB.
To explore
What-
scheme for revival.
Then, yes, my lord. Well, now 23-3, next 2012, order of winding came to be passed. 23-3-2012. Order of winding up came to be passed. 31-1, appellants being aggrieved by the order passed by Second Additional Labour Court for W. so file, the learned single judge held that there was been no transfer of undertaking, as I brought to your lordship's notice earlier. Kindly go to 2014 at the bottom.
That additional labor court said what? Take them to employment. No,
They had claims, my lords, they had filed a writ petition. The writ petition came to be disposed of, reserving liberty to them to approach the labor court to.
Yeah.
and labor
claim
court
their
said,
claim.
That is 31-1. The 33C2 application is filed.
no, what the labor court said. 31-1-2012 you read.
Yes, ma'am.
What it said.
Said that they're not entitled, there was no, because they're entitled for automatic absorption if there's it held to be a transfer of undertaking. It
Please,
held against
please.
them, which is why they approached this order.
Transfer of shares does not per se amount to transfer of undertaking, and
Undertaking.
therefore relief on that premise relief.
Yes,
was-
yes. That narration is correct, my lord. Then, my lord, in 2014, company petition 34 of 2000 came to be filed by SDV Ironworks. This, now the change in the,
What happened to writ appeal?
it was, the appeal, sir, you will have to tell me.
Writ appeal came to be rejected, my lords.
Rejected.
Yes. In
Yes.
fact, there were certain observations against the union saying that they're protracting proceedings and so on. However, that liberty was still there for them to approach.
Yes. Then, my lord, now they transferred, the transferee is SDV Ironworks. Now, my lord would notice this. This is where the
Item number?
14, bottom, page 6, bottom, company petition 34 of 2014 came to be filed by SDB. My lord, may I ask who is this? He is the transferee, sir. SDB.
SDV is person who bought the share.
Yes. Lock,
Mr.
stock and
Will
barrel.
Court,
Lock,
be
stock.
attentive to us.
That,
Whether that SDV, which is spoken of at the rock bottom of page 6, is it the entity which bought the shares?
yes.
Now, I'll explain everything. I'll just take a look.
Well, just
Your lordship,
These are the areas where I wanted the facts should not be complicated. I
Yes.
wanted him to say it and he has said not but difference. Yeah, the effect he is explaining. Then please go to the next page, page 7. Then to continue from the page 6 bottom, company petition 34 came to be filed by SDB. Appellant was not made a party. This is to be noticed. Would your lordship please? 529 capital A says that I rank with paripasu with the secured creditor. Workman, the union, enjoys the status of the creditor insofar as assets are concerned.
creditor entitled to pari passu is the judgment of the apex court.
Please.
That's your case
Yes, 529A is a statutory provision.
of
No,
Companies Act.
Can you have this in my mind? That's sufficient. Then the other thing to be noted, brought to your lordship, we were not made parties to this company petition 34 of 2014. It has effect, the legal effect and the impact on facts. Both, I will be dealing with it in 2-3 minutes only on this subject. Then kindly go to next. Petitioner had knowledge, SDV Ironworks had knowledge that we were the judgment in 35, OSA 35. OSA 35 was filed by us and he was a party and he knew that, but we were not made parties. The one corner of the mind my lords will have that we were not heard in 34. Then my lord,
Whether orders of the company court are orders in rem or orders in personam. What's the position?
Though it may not arise, but just since your lordships asked, I think it may be in rem also.
it is in rem.
But the issue, I'll come to that.
May not arise.
in this case.
Okay.
In R.C. Kapoor, one sentence is there. The company affairs, they're all, they affect the whole society. The commercial transactions are affected by, therefore it has implications and it affects others.
Allah,
One-
the elections when set aside,
Yes.
they affect a large number of voters and constituency. But still election disputes are disputes in personam.
The status of an adopted child, Razia Begum, 57 Supreme Court, my lord would remember. Under 1 Rule 10, the Supreme Court said it affects his status in the society. His adopted status would govern the affairs of the society. Therefore, necessary party. That's the first decision on Order 1 Rule 10. The necessary party. Then, my lord, please permit me to read
Razia.
next one.
Razia Begum versus Shahnaz Begum.
Please.
Yes.
23/1/2014, second shareholders meeting was convened on another application made by SDB Ironworks. The writ appeal came to be dismissed with liberty to file review petition. This, my lords will have it in mind, and the genesis for the present the review petition filed, and the present appeal is against the non-consideration of the review petition. Then review petition came to be filed on 2014. Review petition was dismissed with certain observations. Application section 33C1 was filed before the petition. The note of Mr. Subra would say it is pending, but I'm told it's dismissed. Am I correct, sir?
Writ appeal is dismissed.
Yes, Miller, it's dismissed. That's where I require his help. The then order dated 23 to pass in this company petition 55 thing, and other connected petitions came to be recalled. This appellant was not heard. But we have two company petitions. One I referred to earlier. It is 34 of 2014. The present, the one concerned in 23/6/2015. Third item from the bottom is the order dated 23/3/2012. Passed in company petition 55 of 97, and other connected matters came to be recalled. The appellant was not heard. This is second occasion where we are kept out of consideration. Then Miller appellant filed a review petition in the 15. Review petition was disposed of. I would now read the review petition. Before reading the review petition, may I
Let us
request
see the order.
Millard, I would request my lord's kind attention to this
28.
this is filed by the Employees Union, page 10, the present appeal, and the order impugned is at page 28.
28.
Well, there are two occasions for us asking us to seek review, and this is what the learned single judge would observe. Page 33, Your Lordship, may please.
33.
33. We have passed the stage of proposed the scheme of arrangement. The arrangement was taken in appeal, and the Honorable Division Bench said file review petition. The proposed scheme of arrangement filed by the petitioner seeking revival of the company is in liquidation contains clause 10 of the scheme of arrangement. The same is produced as Annex 8 to the petition, wherein it is contemplated that upon the scheme being effective and payment of the dues to the company to KADB, KADB shall execute the sale deeds in favor of the company in respect of the leasehold properties described in A6, para 2. Petitioner has now realized that it is settled legal position as held by the division bench of this court in Karnataka Industrial Areas Development Company versus Hegre and Gole, wherein it is laid down as follows. A harmonious reading of these two provisions makes it clear that the power is vested in the court to sanction a compromise or arrangement, and at the time of according such sanction or subsequent thereto, may issue directions for supplementing the scheme, which is approved, including the power to make such modifications in the scheme if it considers necessary for the proper working of the compromise or arrangement. If the court is issuing any directions, I will not read the rest of it. Please go to paragraph 4 now. Page 35, paragraph 4. The petition is filed by the assignee of the secured creditor of the respondent company for sanctioning a scheme of the arrangement, where under the company in liquidation is proposed to be revived by the assignee of the secured creditor. The petition is said to be proprietorship concern, having its office at Vijayawada and represented proprietor. Therefore, there are two secured creditors, namely IDBI, IFCI, who have assigned their debt in favor of the petitioner. This court has directed convening of the meeting of the equity shareholders, debenture holders, secured creditors, and unsecured creditors this is under 529, 520A of all sections also of the company for the purpose of considering and approving with or without modification to the scheme. Then, my lord, please turn to paragraph 5. Registrar of Companies had filed a petition on behalf of the Regional Director, Ministry of Corporate Affairs, Hyderabad, with certain observations. The petition has filed the reply complying with the objections and were raised. No further objections are filed. The petition is this is where the law is or the decision is taken. The petitioner is an assignee of the secured
Learned
creditor.
single judge says, except complying the objections, there is nothing more. Page 37, page,
Yeah,
inner page 10.
And-
Petitioner is not raised. No further objections are filed.
Yes.
Yes.
Where does it take us to as far as the labor union is concerned? It's only concern. I'm here only for the limited point of this. Millard, this scheme proposes two things. One is, yes, the world is to be wound up, and how the properties are to be utilized and exploited is another issue. As far as the union is concerned, interest of the union is paramount and it is not protected. We are not even made parties in the proceedings.
Suppose if you were made a party,
Millard,
what you would have suggested?
Millard, see, what is suggested is not followed. What were the use of our suggestions? The suggestion of the Honorable Court is, the company court is, it should be sold by auction. A whole meeting is to be held. Bidders must participate and do it. What they have done is sold it as a private willing vendor and a willing purchaser. That's exactly our complaint. Millard,
Now, winding up order is recalled. That's all.
winding up.
Proper interests are affected by recall. Suppose if the order was there to wind up, perhaps you would have been definitely.
529A also. 529A applies for a company in liquidation. The liquidation order will be recalled. So there's no winding up order.
No, there is no winding up order at all.
There are
Your role, kindly read 520. In fact, we read file
No,
and then we come. Anyway, just where is your locus to you at this stage? Let us read 529A of the erstwhile act.
No, it's not difficult to understand the consequences of reading the earlier the records. Well, I'm aware. I'm with the Honorable Court. All I'm suggesting is, subject to my Lord's approval, well, the company court passes an order saying that it should be, the scheme has to be implemented in a particular manner. The property has to be sold in a particular manner.
Correct.
That is not followed is the first submission. Second thing is, when the company petition, I mean, this OSA 8 of 2016 was pending. Well, one day when Mr. Subrao had gone out of India and he had gone to see his daughters, perhaps for the last time, then in his absence, the petition was dismissed. Then for restoration, this application filed in this restored.
I agree. And how you are aggrieved by this order?
My lord, it's a little faster for me.
Take your own time.
I'll try to manage.
But just I wanted to know, when I read it was 1 AM.
I would
Just
not,
a question
the moment your lordship gets the season of the matter, I would withdraw. The moment.
You are entitled.
Because there's no meaning in arguing for the Honorable Court, which has, when it's appreciated. Well, I am on this narrow point. Now, during that interregnum, there was an earlier order of the single judge and the division bench not to alienate the property.
Yes.
That will have some. We had filed a contempt petition when I was with the leave of this Honorable Court. I went out of the shores, beyond the shores of this country, and during that, on that given day, the matter came up for the first court, and my colleague asked for a week. The Honorable Judge said, "Why did you ask for 2 weeks' time?" The fairest of the fair mentioned that I'm not opposing adjournment. Adjournment will be granted, but I'm pointing out one thing, namely, the property has been sold during this interregnum, and at that time there was no order of injunction or anything. But this is not a case where injunction is issued. The order is on the basis of an undertaking given by the learned advocate for the
When undertaking was given?
Beg your lordship?
When it was given?
Yeah, healthy. ಅದು ಆಡ್ಬೇಕಲ್ಲಯ್ಯ ಇಲ್ವದು ಅಂಡರ್ಟೇಕಿಂಗು
We'll go, ನಿಮ್ ಡೇಟ್ ಗೊತ್ತಿದ್ರೆ ಹೇಳಿ.
Milad,
I'll just pull out the contempt file. 3/12/21. 12/21. There was an undertaking that the respondents. had
annexure,
not followed-
Milad, I'll make the order
Page.
available.
ಹಾ.
ಇಲ್ಲಿ
ಪೇಜ್ ಹೇಳಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಅದು ಆ ರೆಕಾರ್ಡ್ ಬರ್ಲಿಲ್ಲ.
Okay, okay.
ಇಲ್ಲಿ ಕೊಡಿ.
It was in the contempt. That contempt is closed.
ಇಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಯ್ಯ, ಇದು ದಿಸ್ ಇಸ್ ಇನ್ ವರ್ಡ್ ಆನರಬಲ್ ಡಿವಿಷನ್ ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ಕುಮಾರ್ ಅಂಡ್ ಮಿಸ್ಟರ್ SAJ. It's in OSA 8 of 2016 only. I think in the present records 23/12/2020. ಇಲ್ಲಿ ಒಂದು ಇದನ್ನು ನೋಡ್ಬಿಟ್ಟು
ಕೊಡಿ ಕೊಡಿ.
ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆಯಾ?
ಅಲ್ಲ, ಐ ವಿಲ್ ಗಿವ್ ಬ್ಯಾಕ್. ವಿಲ್ ಗಿವ್ ಬ್ಯಾಕ್ ಟು ಯು.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, no, we have given copies, 6 copies to you. They are waste.
ಇದು ಯಾವ್ದು ಪೇಪರಲ್ಲಿ ಇದೆ ನಮ್ಮದ್ರಲ್ಲಿ? This is already disposed of ಅಂತ.
Disposed of. Disposal of the company, I mean, contempt petition has nothing to do with the complaint that I'm now making. It's an undertaking given to the honorable court.
ಈ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ ನಮ್ಮ ಬುಕ್ ನಲ್ಲಿ.
That's in the order sheet itself, it is there.
ಇತ್ತೊಳಿ.
Well, I'm at a very narrow point. I think with this I should, ಕೊಡಿ. ಇದೆಂತ ಕಾಣುತ್ತೆ?
Lords, like have a look at the contempt order. Contempt order has a list of all the dates.
ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
In fact, sequentially. there
ಕಾಪಿ
are-
ಇದೆಯೇನ? ಎರಡಿದಾವ?
ಎರಡೇ ಇರೋದು ನಮ್ಮ-
ಅವ್ರಿಗೆ
I mean,
ಶಂಕರ್ ಸರ್ಗೆ ಒಂದು ಕೊಟ್ಬಿಡಿ.
ಇಲ್ಲ, no,
So that it becomes easy, handy. Because very thick file ಅದು. Locate ಮಾಡೋದು immediately ನಮಗೂ ತ್ರಾಸು, ನಿಮಗೂ
no,
ತ್ರಾಸು.
just in a nutshell, what happened in this is, there was an undertaking not to alienate certain properties in this OSA. I'll take my loss through the dates. That OSA came to be dismissed on a particular date for non-prosecution. Immediately after that, steps were taken to alienate the property. It was alienated.
During dismissal,
After the.
post dismissal.
post dismissal, prior to restoration.
ರಿಸ್ಟೋರ್ ಆಯ್ತು ಆಮೇಲೆ.
Yes, ಆಗಿದೆ.
January that restored. So.
ಹಾಗಾಗಿ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು, once this is restored, whether orders are also restored or not was the issue which we
Automatic
can.
restoration.
Interim orders, in fact, I checked the legal, this thing, that a very interesting legal issue there, Manoj.
Is now before the larger bench,
They do, in fact, they do get restored, it's now before the, your lordship is absolutely right.
not
So
undertaking.
in fact, I checked before the contempt, but their lordships felt there is no question of any contempt having been committed or willful disobedience, because as on the date of alienation, there was no order operating, because there was no appeal survivor. So on that ground, the appeal came, sorry, the contempt came to the.
No, it proceeded at the
Shankar said
footing.
the other day,
Otherwise, that-
once he said this, we remember. In this case, a very important question arises in the light of a plethora of judgments of various high courts, whether an interim order would revive on main matter being revived
Restored.
or not. Another point ಅಂತ. But ಇಲ್ಲಿರೋದು interim order ಅಲ್ಲ, undertaking ಇದು. What applies to an interim order, whether it would apply to undertaking also is another question.
On an academic point, my lords, that issue.
May not arise.
This it won't arise, because the scope of the OSA, I'll come to the, I'll just,
Okay.
what are the relevant points?
Yes. But there is another order. ರೆಡ್ಡಿ ಅವ್ರದ್ದು ಒಂದ್ ಲೈನ್ ಆರ್ಡರ್ ಅದಲ್ಲಿ. ನೋಟ್ಸ್ ಇದೆ, notes.
I told my lord, Mr. Samit, instruction reviews.
On all transactions which are. ಇಲ್ಲಪ್ಪ, see, ಇದೊಂದು ಆರ್ಡರ್
Samit instructed me to submit that your lordship sitting in Arwa, one of,
ಸ್ವಲ್ಪ ನಿಮ್ಮ ಮೈಕ್ ಅನ್ನ ತೆಗ್ಸಿ.
Samit.
Many students ಇರ್ತಾರೆ, youngsters ಇರ್ತಾರೆ. They expect, professors tell us, some discussion ಆಗ್ಬೇಕು. It may be little waste of time also,
Correct.
but the bar's quality will improve.
No, I'm sorry, I didn't notice it was switched
Okay.
off. Sometimes we put it
Okay.
off because when we are talking, we don't want to disturb the court. Now, there
Sometimes
is.
known things ಅನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಿ ನಾವು. Because many youngsters ಇರ್ತಾರೆ.
Correct.
ಅವ್ರನ್ನ ನಾವ್ ಹೆಂಗೆ ಮೋಟಿವೇಟ್
true.
ಮಾಡೋದು? ಎಲ್ಲ ಉತ್ಕತ್ ಕೊಡಕ್ ಆಗಲ್ಲ. ಈಗೆಲ್ಲ ವಾಟ್ಸಪ್ ರೀಡಿಂಗ್. ಹಂಗಾಗಿ ನಾವು ಸ್ವಲ್ಪ ಡಿಸ್ಕಷನ್
No,
ಮಾಡ್ತೀವಿ.
certainly. No, in fact, your lordships in CCC number 100, 127 of 2019. Correct, no? Let's just show that.
100,
127 of 2019. I think Mr. Samit himself had appeared in that case. Maharaj. Your lordships have taken a view that undertakings and interim orders
Different.
are the same. Are the same.
same
And
for
they,
the
and
purpose of
they do have
revival.
the same effect. That's what I'm told. I honestly, I have not had a look at it. Like I could put Samit, because
You argued that-
members.
In that,
ಕಾಪಿ ಇದೆಯೇನು?
ಅದ್ರದ್ದು judgment copy handy ಇಲ್ಲ, I can get that judgment copy.
ಬಟ್ ಆ ರೀತಿ ನಾನು ಹೇಳಿದ್ರೆ ಸಾಮಾನ್ಯವಾಗಿ ಅಂತ ಮರೆಯಲ್ಲ ನಾನು.
Indeed, my
Very
lords.
important
What
question.
has happened is, in that matter, there was a breach of an undertaking of a loan that was extended to some directors, and they had obtained an interim order on the basis of certain undertakings. given.
Where we imprisoned the directors
Indeed,
of
my
a
lord.
sugar factory
Indeed, my lords, that matter.
at
my
one.
lords.
But that went to Supreme Court, na?
Only the order of sentence has been stayed, my lords, by the Honorable Supreme Court. That matter is still
Conviction is
pending.
not stayed, sentence is stayed.
Okay.
Well, in this case, there is another order dated 13/3/2021 by another division bench. That is another undertaking. ಇದು ಕೊಡಿ ಸಾಹೇಬ್ರಿ.
That undertaking revise ಅಂತ ನೀವ್ ಹೇಳೋದಾ?
ಹೌದೌದು. Undertaking is never lapses unless the court relieved from the undertaking. There has to
Even
be.
after dismissal of the case also.
Yes, that's the, say, when an undertaking went to the court, it can be discharged by the court by passing an order relieving the the person who has given the undertaking from responsibility. Stay order is different.
ನಮ್ಮ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗು ಸ್ವಲ್ಪ ಡಿಫರೆಂಟ್ ಇದೆ ಇನ್ ದ ಸೆನ್ಸ್ ಇಫ್ ಡಿಸ್ಮಿಸಲ್ ಈಸ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಹಿ ಹ್ಯಾಸ್ ಅಂಡರ್ಟೇಕನ್ ನಾಟ್ ಟು ಎಲಿನೇಟ್, ಅವಾಗ ವಾಟ್ ಯು ಸಿ ಇಸ್ ಕರೆಕ್ಟ್. ಇದು ಏನೋ ಮೇನ್ ಮ್ಯಾಟರ್ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋದಿರ್ತದೆ. ನೀವು ಇಂಜೆಕ್ಷನ್ ಕೇಳ್ತೀರಿ, ಅವಾಗ ಅವ್ರಂತಾರೆ ಇಂಜೆಕ್ಷನ್ ಬೇಡ, ನಾವೇ ಹೇಳ್ತೇವೆ ವಿಲ್ ನಾಟ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ
The
ಪ್ರಾಪರ್ಟಿ.
next situation, the order of dismissal is made only on the basis of submission made by, I shouldn't name, but it's necessary to say it. The senior advocate, then senior advocate who says that there is nothing that survives for consideration and did dismissed. We are not heard. It's not on merits. It came before another division bench. The advocate said, no, there's nothing that survives in this case. They have taken money. The court accepted the situation. Subara was absent. Now, that order does not relieve the person who had given the undertaking from liability. Undertaking is to the court. That's the essential thing. I think we have practiced in the trial court. We know its consequence. And ಅಲ್ಲೇ ಮುಂಚೆ ನಿಮಗೆ ₹1 ಸ್ಟಾಂಪ್ ನಲ್ಲಿ ಹಾಕಿ ನಮಗೆ ಅದು ಹಾಕಿ ಕೊಡ್ತಾ ಇದ್ರು, ದಿ ಶ್ಯೂರಿಟಿ ಬಾಂಡ್ ಅಂತ. ಅದರ್ ಇಸ್ ಒನ್ ಕ್ಯಾಟಗರಿ. That is Justice Hegde's decision is that is enforceable and the matter requires to be considered. Now, the present situation is an undertaking is given to the court for what purpose? To prevent a positive order of injunction. This
They have understood. Question is not that. Question is, if the case is decided on the undertaking itself, then undertaking binds.
I think I shouldn't weary your lordship with my submission. Please go to the notes of submission ತಗೊಳ್ಳಿ.
ನಾವು ಒಂದು ಸಣ್ಣ ಪ್ರಪೋಸಿಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ ನಿಮ್ಮ ಹತ್ರ. Since you are an author, you also, since you studied abroad also, maybe your books are in the writing now. Our question is, where pending adjudication of the main matter, some undertaking is given so that the matter is not rendered infructuous. And thereafter, the matter is dismissed, the list is dismissed.
Not on merits. That's the way.
Assuming
I have followed. Technically.
on some XYZ reasons, certainly not on merits. Whether that undertaking will still continue after dismissal.
This is the word used is automatically revives.
See, you tell us one more situation. Suppose the case was dismissed, not on merits.
Then transaction happens in the interregnum.
Transaction happens, and hereafter, let us say, it is not revived at all. For years together, it is not revived or restored. Then you mean to say that all those transactions are void?
Continues to exist and continues to operate is the question.
I think
Your lordships have made the illustration clear.
they have to take a take a view that whatever the transactions took place during the interregnum, that is date of dismissal and date of restoration, that will not be affected by the undertaking.
I think-
Otherwise,
Well,
suppose you may choose not to restore it,
At all.
then what?
how the Supreme Court used this is that page, notes nodi.
In fact,
Page-
similar aspect is treated by 3 high courts in the country.
Yes.
That was under section 52 of Transfer of Property Act. Lis pendens.
Lis pendens.
Case gets dismissed. And appeal is filed
Yes.
years thereafter. And delay is condoned. In the interregnum, transactions do happen. What happens to those transactions, whether lis pendens attaches or not, in that direction? Discussions are there in at least 3 high court judgments.
There are 2 aspects here. I'm not.
No, just I'm
I-
giving
I'm-
reflection.
No, no.
We have understood.
Millard, I'm not answering my lord's question, but I'll give the next instance. Millard, the scheme would say, would lordship turn to this, so that.
That decision we wanted to see.
Notes of submissions is cyber recording.
Notes of submissions could.
That is submitted recently on 6th December. Kindly go to page 140.
100 and
Page 146 is the decision of the Honorable Supreme Court, 3 judges. The discussion is at page, paragraph 117, page 159.
in 9.
I have the leave of the Honorable Court. In the case of Shivaraju versus Sharanappa, it has been held that the question whether the restoration of the suit revives ancillary orders passed before the dismissal of the suit depends upon the terms in which the order of dismissal is passed. In this case, the order of dismissal does not say that the undertaking is absolved or set at naught.
Nor it will say undertaking will continue.
Yes.
We will argue that.
Yes, yes,
Where do we
yeah,
stand?
No, actually, we are on the 2 sides of, therefore we are bound to disagree. Is upon which the order of dismissal is passed and the terms on which the suit is restored. If the court dismisses the suit for default without any reference to the ancillary orders passed earlier, which is the case here, then the interim orders shall revive as and when the suit is restored unconditionally.
But where is the interim order in this case?
The interim order is that he should not alienate.
No, it was an undertaking.
So undertaking is, I should.
It stands on the same.
Undertaking
footing.
is it's a worse footing. Undertaking, as far as he is concerned, it's on worse footing. It's an undertaking given to the court. The only way to escape from the clutches of the undertaking is to be relieved from that by a judicial order. This is one aspect. Second thing is, in the scheme itself, they said the orders, no property shall be alienated. I will show that. This is
No, but one thing, Mr. Shankar, we got the pith and substance of your argument now. How this question will crop up? How this question arises in this case? Very interesting question is all right. But where is the relevance of that question to this proceeding?
529A does not apply at this stage.
That's what he said.
At this
It
stage.
appears that way.
Then the scheme which was formulated for acceptance stipulates that they shall not alienate the property in any other manner except by bidding, calling for tenders and everything.
No,
Here-
that order goes now. That is recalled now. Same order is
No,
recalled.
that's not recalled. That's not recalled. Am I correct, sir? Justice Anand Reddy's order framing the scheme.
Now, my lords, can I just?
No, if it is
Just
true-
clarify that
if it is
position.
recalled, no, if it is recalled, that's
It is now, as of now, there is no order of liquidation. The order of liquidation, Justice Anand Reddy's order now stands recalled. There is no. order.
not liquidation, scheme.
The scheme was there in the liquidation order itself.
No. That two separate orders.
It was revival order.
Yes, for revival. For revival, a scheme is 391 and 394. Under 391 and 394, this order is passed. That order is to this effect. You shall not alienate the property, leave movable and immobile. ನಾನು
I just make one request subject to what Mr. Shankar says. Could your lordship permit me about 5 minutes? I'll just give a, just the brief factual background.
ಅವ್ರು ಬಿಡ್ಬೇಕಲ್ಲ ನಮ್ಗೆ.
That's a subject.
ಯಾಕಂದ್ರೆ
ಏನಾಗಿದೆ?
ಒಂದೇನೋ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಸ್ಟ್ರಕ್ಚರ್ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
Correct. No, that's
ಆ ಪ್ರಕಾರ ಹೋಗೋದಿರ್ತದೆ. ಹಂಗಾಗಿ ವಿಲ್ ಕಮ್ ಟು ಯು ಆಲ್ಸೋ. ನೋ ಇಶ್ಯೂ.
ಪ್ಲೀಸ್ ಟರ್ನ್ ಟು ಇಲ್ಲಿ ಹೇಳ್ತೇನೆ. Well, I showed to your lordship the order of one division bench at page 14 in this compilation.
There is a version is very scheme itself says there shall be no alienation of the property. Even assuming that this undertaking is liquidated by the dismissal for default and not restored on the restoration of the main matter, still the scheme says like this. Therefore, there is a culpable conduct on their part under the version act.
Ultimately, that's one. On two scores. One is undertaking given to the court. Your lordship said liquidated. Permit me to call it a discharge.
Now, why use it that word?
No,
Because
no,
in
no,
company
no.
jurisdiction,
No, effect is
liquidation is a very popular word. Therefore, nearby word I chose.
Your lordship, the word used has effect, but word used is in law is discharge.
Discharge.
It's not discharge, number one. Number two is in the scheme, which is not annulled. The order is you shall not alienate the property except in a manner. Hotel nalli, ನಮ್ಮ ಖರ್ಚಿನಲ್ಲಿ ಹೋಟೆಲ್ ನಲ್ಲಿ ಮೀಟ್ ಮಾಡಬೇಕು. Then we should be allowed to come. We should participate. These are the terms. That is violated. I think they narrow this. Let him argue. I have no objection. But I will give.
No, just ನಿಮ್ದು ಆದ್ಮೇಲೆ ಮಾಡ್ಲಿ. ಯಾಕೆ we don't want to come in your way. ಏನೇನೋ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಸ್ಟ್ರಕ್ಚರಿಂಗ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರ್ತದೆ. With that view you come to court. We don't want to disturb that.
My lord, please. Page order. That order itself is extracted in my notes of submission.
Page number?
Page number 2, my lord, it is brought to the notice. Middle. Page number 2 nale, it is brought to the notice of the Honorable Court that on 18/1/2016, the learned single judge dealing with RP 498 of 2015 and RP 540 passed an order to the following effect. This one, yeah. Page 2 of the notes of submission.
Ida? 2.
Yes, page 2 of the. ಮಧ್ಯದಲ್ಲಿ ಒಂದು
Not to alienate both the movable and immovable properties.
Yes, that order I will show you. Page 7 ಹೋಗಿ. Kindly go to page 7 of this compilation. Kindly go to page 7. Page 9 is the relevant portion. Please go to page 9.
Not to alienate both the movable
Respondent
and
number is
immovable.
directed
Yes.
not to alienate both movable and immovable property if they are not already alienated. This order is violated.
This was made on
16/1/2016.
18/1/2016.
Yes. This is a positive order.
Then what happened to this?
One more. I'll request my lord's kind attention to page 74 now. Page 74.
74.
Another division bench.
Saji P. John.
Saji John, learned advocate, appeal for respondent number 2 and 6, submit that during the pendency of this original side appeal
But alter the nature of the properties,
And
not
the-
create any encumbrance.
or create any encumbrance, his submission is placed on record. The court has awarded a positive order recorded the submission of the advocate, Subbarao learned senior advocate, appearing for appointment, submit that he is satisfied with the submission made by learned counsel for respondent number 2 and 6. Accordingly, stand disposed of. There are two undertakings, go to two different judicial benches, and there's a positive order of learned single judge while framing the scheme. And then here, this is the order.
This is on 3/12/2021.
Yes, my lord, 312. I have now pointed out 3 orders to the Honorable Court. Then, my lord, in the scheme formed,
Yes, sir.
the scheme is at page 59, Allah? Page 59 of this compilation. Illa, nama original record, munche otta idnala aa record. The scheme of arrangement for revival.
Yes.
I will be praying my lord's kind attention to
Page number
page number 59 anta ನನ್ನ ಇದೆ.
59.
Annexure A, it's appended to that petition. You are right, sir.
Yes.
But please
Scheme.
turn to page 61. That is I have the leave of the Honorable Court to read this paragraph. ಇಲ್ಲಿ ತಮ್ಮ ಗಮನ ಇಲ್ಲಿ ತರ್ತಾ ಇದ್ದೇನೆ. On page 61.
Company petition number so and so.
Company petition 55 preferred by one of the creditors of the company, namely Mr. Swami Construction Company, was preferred by yet another creditor, Mr. Champala Sorso, under section 433 of the Act. During the pendency of the above petition before the Honorable Court of Karnataka, BFR section 2 also had recommended winding up the company, petition number 88 2000. Meanwhile, company application 448 of 2006 was filed by Shrishma Employees Union for impleading under Rule 34. That other application. That we had filed an application for impleading and nothing happened. Please now turn to.
Hello, what turns out from this narration?
We are to participate in the sale.
No, that we do.
If that is brought home, I shouldn't weary my lords. The point I am now submitted to the Honorable Court is there are 3 positive orders. In addition to it, the law permits us to participate in this thing, especially when a scheme is formed 391 and 394. And we have been kept out of it. And it looks as though a willing purchaser is selling to a willing buyer.
What happened to that impleading application?
I'm in dark. I couldn't get it from the record.
They thought to impede themselves when the first order of winding up was passed. The impeding application came to be disposed of along with the main order where the company was ordered to be liquidated. Impeding application came to be rejected. They filed an appeal. The division bench said, no, this order could not have been passed without hearing them. Therefore, the order of winding up was set aside. The division bench sent it back to the learned single judge. Then, my lord, I'll take my lord for that appropriate. Then the learned single judge notes that even at this stage, after having gone to the division bench, you yourself have not come forward with any scheme. Then we have given you an opportunity, you have not come forward. Then once again, company is ordered to be wound up. Then, my lords, that's when this SDV Ironworks enters the frame and says, we are coming up with a scheme to revive this
That
company.
observation of Justice Anand Bhaira Reddy.
Open a second.
Second one.
Second
Yes,
one is
second.
first
Open up.
Justice
Except objections, there is nothing more. They have said that.
I'll point it out. I'll point out the relevant.
No, you see, we wish to cut down. I don't want to argue.
Just we want to know what happened to that impleading application.
Rejected. But then the appeal, so the company petition was restored specifically at their behest because they were.
No, restored means application is also restored. Then what happened to that application? Impleading application, how it was treated?
They were heard.
They were heard in the matter.
We participated.
Regardless of formal orders on the impleading application, we were heard in the matter.
We participated, we assisted the court in doing, and that is exactly the reason why the scheme says, yeah, we should be heard. The employees also should be welcome. Our hotel ge, our tindi alla ಆದ್ಮೇಲೆ ನಾವು ಅಲ್ಲಿ ಒಳಗಡೆ ಹೋಗ್ಬೋದಿತ್ತು. ನಮ್ಮ ತಿಂಡಿ ಇಲ್ಲ. ನಮ್ಮ the workforce is second grade citizen. ಅದು ಪ್ರಯೋಜನ ಇಲ್ಲ ಮಾತಾಡಿ. now we are with Millet. The employees must be heard at all stages is the submission, and that is countenance irrespective of 529A. Now, 3 positive orders plus the scheme says we should be heard, and how the property will be sold is set out in the scheme itself. That is not followed. The sale is in violation. It has to be restored. And
While framing the scheme, they should be heard anta ideyano position. Order ಏನಾಗಿದೆ ಅಂತ. Regardless of order, the legal position.
I think we'll look at it.
I'll just take my lords and then I'll leave it to your lordship. I'll just, if Mr. Shankar is complete.
ಅಲ್ಲ ನಾವು ಕೇಳ್ತಾ ಇದ್ವಿ ಇದರಲ್ಲಿ while framing the scheme you should be heard ಅನ್ನೋ ಬಗ್ಗೆ ಎಲ್ಲಾರು ಇದೆಯಾ?
ಇದೆ. ಅದಿದೆ. I'll be pointing out to that. That is certain. That is certain. Justice Anand Reddy ಅವರು he specifically says they should be heard, and ಅವ್ರನ್ನ ಹೇಳಿದ್ನಲ್ಲ ಮೀಟಿಂಗ್ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ನಮಗೆ. We should be invited. We should part.
Correct. We are asking a concrete question to you. In framing the scheme.
One second.
Okay.
So Subrao celebrated client.
Correct.
Therefore, in 35 of 2000 OSC 35 ಒಳಗೆ that is remand ಆಗಿದೆ. And
ಅವ್ರನ್ನ ನೀವು ಮಕ್ಕಳನ್ನ
I'll point out that.
ಅಲ್ಲ, you can ask him to sit beside so that he will assist you. Facts ಅವರಿಗೆಲ್ಲ ಗೊತ್ತಿರ್ತದೆ ಯೂನಿಯನ್ ಲೀಡರ್ಸಿಗೆ.
Page 143. Page 143 ಇದೆ. OSA 34 ಅಲ್ವಾ? Sorry, 34.
Yes.
Page 143 is the order.
Honorable Justice Gopal Gaud and Arali Nagaraj.
Page 152 ನೋಡಿ. 152 to 154.
The commencement is at page 152, the narration. And if it is Justice Gopal Gaud, he will have a pass on. Para 5 ಅಲ್ಲಿ ಕಾಣುತ್ತೆ ನೋಡಿ ಸರ್. Am I correct? Para 5. It is to be noted the employees union had also ನನಗೆ ಇಲ್ಲಿ
Next, Justice Bopanna's order. The division bench order is at page 152.
ಇಲ್ಲಿ ನಮ್ಮ impleading application is remitted to the learned
For
signature
consideration.
for consideration.
ಅದೇನಾಯ್ತು ಮುಂದೆ?
Next, page 155
Then-
is the order.
Then Justice Bopanna's order. ಇಲ್ಲಿ the narration about 391 para 3. Having heard the learned counsel appearing for the rival party, the subsequent portion which is evident is that the learned counsel representing the employees union and the staff members had an opportunity to put forth their contention, but they have not put forth any scheme before this court whereby the company can be kept afloat. In the meanwhile, during the pendency of these petitions, the assignee of the secured creditors, however, filed an application at section 391 of the Companies Act in praying this court to direction convene the meeting and shareholders, secured creditors and unsecured creditors to consider the proposal for revival of the respondent company. This court allowed the application to then fix the meeting. Accordingly, the meeting of the shareholders and the creditors were held. The scheme proposed by the assignee of the secured creditors did not secure the proposal approval of the unsecured creditors and the shareholders. In that view, the scheme had failed, and such the petitions was winding up had to be considered on its own merits. Accordingly, the same is being considered at this juncture. And it is for this reason I gave a suggestion outside the court to the learned senior advocate. We should buy peace from the workmen.
So So by this order, company was ordered to be wound
Wound
up.
up once again for the second time. I stand corrected. The first order was Justice Sabahits, not Justice Anand Behra. The
Ah.
first order of winding was Justice Sabahits, set aside by a division bench.
Division bench.
Second
Saying
order,
that
Justice
they ought
They ought
to
to have been heard. Now they were heard, and once again, the same conclusion was arrived at.
Against this,
Then a scheme of arrangement was, I'll come to that one. Because then the company was ordered to be revived once again. Now that it is that order which is now challenged before your lordships.
Our submissions rest on the two premises, nothing. And I have made it clear to the Honorable Court. Three under orders, positive orders by this Honorable Court, accepted undertaking. Second thing is, the scheme would say that we should be heard. The law also says they should be heard. I think I should rest my submission with the right to reply. The others.
yes.
Now, just a few relevant dates and some observations of this Honorable Court I'll take, my lords. The first order, my lords, may kindly see at page 122 of the appeal. I will submit.
122.
Page 122, my lords. That is the order dated 27th July 2006. Sorry.
You're right. You want to say anything?
He appears to be with me, so let him
You.
know.
Yes. We loosely assume
Apologies.
where voice is low, merits are also not that. Sometimes reverse also we assume. Yes. Very well, very well. Nice.
It is the second case here, my lord.
In the second case, adenadu,
My lord, it is company application 237 of 2023.
who are you?
Which is connected, my lord, I was the employee of the company. That is now
Are
revived.
you a member of the trade union?
No.
You are not.
This is two
Where have you
separate.
stated that you are not a member of the trade union?
No, my lord, I
Because
have
once a
stated.
trade union takes up the stand, Justice Gajendra Gadkar
My lord,
said,
the-
individual employee need not be heard in the
The
matter.
OSA which is filed, my lord, representing trade union, that has no concern with respect to this. Because my submission is, my lord, that the first submission is that I have filed application under section 392 of Companies Act. My lord, it was not supposed to be connected along with this OSA. This was the first submission that I had made, my lord, last date of hearing. I want to make submission as to why this cannot be heard along with this OSA. Lord, the entire jurisdiction under section 391 and section 392 of Companies Act is completely different. Lord, what is challenged before this honorable court, challenge in the order passed under section 391 of Companies Act, my lord, is to see as to whether that order is properly passed or not. But with respect to section 392 of Companies Act, it is the jurisdiction of the company court which has passed the order to see as to whether the scheme which it has sanctioned, whether it is being properly implemented. If not properly implemented, then what are the next steps that has to be taken to make sure that it is properly implemented?
Whether this court has no such jurisdiction,
My lord,
being the appellate court.
it-
Powers of the appellate court may not
Powers-
avail with the company
But
court.
with
But
respect
our
to that, my
powers
lord,
are,
My learned friend is right. Now, what is under challenge? I'm grateful to my learned friend for having brought some focus to this the appeal, my lords. Now, the appeal is specific to the scheme of arrangement that was sanctioned by the learned single judge. Now, if your lordships were to set aside the entire scheme itself,
then
then-
that question will
then
not
that
arise.
question may not arise. And the order itself is set aside. In which case, then the liquidation order will get revived. Then, of course, these applications become entirely infructuous because there is no scheme at all. So, but if your lordships were to uphold the order, then there is a scheme of arrangement. Then my learned friend may have to make out a
Then he
case
may,
to say,
we may have.
he may have to
Suppose
make
if
out a case.
as itself is set aside, then rest of the things will fall to the ground.
true, my lord. If this is upheld, at that point of time,
separate here ಮಾಡಬೇಕಾಗ್ತದೆ. Because its fate depends upon
Correct. Then,
fate of this.
correct. Like I said, if your lordships were to set aside the order, then liquidation order gets revived. Then this application itself goes because the arrangement, then scheme of arrangement goes. But if your lordships were to uphold the scheme of arrangement, which was approved by the learned single
Then
judge,
he will be able to argue.
then
his
he may have to make out a point that the scheme of arrangement
Is
is
not
being
properly
violated in
implemented.
ABCD manner.
You're right. Then we'll dissociate that matter.
Or lordships may, they'll go back to the learned single judge, your lordships may have to decide the
No,
OSA.
that
in the-
question will, suppose in the, it
Correct.
all depends upon what we are going to do in
Yes,
this
ma'am.
matter.
Then a lordships may hear, may I suggest this, your lordships,
We were employed in the year 82. Many may not be surviving also. Instead of that, let them have peace.
We are ready, but he says, dissociate me.
in fact, like in all fairness, it was Mr. Shankar who suggested before the coordinate bench that all these applications should be heard together. Of course, I didn't, I don't have any objection even now, either way,
But
but.
that his question arises, depending upon the fate of, suppose if we set aside,
Correct. Then the company has to be liquidated.
that's what. Therefore, ಈಗ ಇಂಪ್ಲಿಮೆಂಟೇಶನ್ ಆಗ್ತಾ ಇಲ್ಲ ಆಗ್ಬೇಕದು ಅನ್ನೋದು ನಿಮ್ಮ ವ್ಯೂ ತಾನೆ.
Otherwise, my lord,
ಅದು ಆ ಪ್ರಶ್ನೆ ಹೇಳೋದು ಯಾವಾಗ
section
ಈ ಫೇಟ್ ಮೇಲೆ.
section 392, what it says that the power of the company court, when it has sanctioned the scheme, to
It
make
is the
this
duty
pass,
of the company court to ensure its
Please, madam.
implementation.
and if it is not implemented at that point of time, it can pass order for liquidation also. It has, my lord, at that point of time, an opportunity is given to the propounder of the scheme to make sure that whatever he has undertaken under the scheme, that he implements that. If he cannot do that, at that point of time, it can wind up, I mean to say, my lord, it can order for liquidation also. But my apprehension is that, my lord, here OSA, my lord, if this is connected with OSA, all my arguments are subsequent to sanctioning of the scheme and not prior to that, or as to I'm not challenging the
Your
order of the
whole
sanction.
petition is structured on the substratum of there being a scheme.
Please, my lord. And that is,
If scheme goes, petition goes.
if scheme goes, then my, please, my lord, petition goes.
If scheme is retained,
Even
then
then,
you
then
will
my-
have your voice to say something.
One aspect your lordships may have to consider is also the timing of this application. Now, scheme was sanctioned way back in 2015. Review petition filed, review petition rejected. Now, my learned friend may have to point out what took him 8 years thereafter. Because in the meantime, we were proceeding with the scheme subject to those few undertakings here and there.
Whether section, ಯಾವ್ದಾದ್ರು section,
392.
does it prescribe any
Limitation.
limitation?
No.
There's no limit.
My lord,
ಅದು as long as scheme is being implemented,
Correct.
so long they are entitled to maintain it ಅಂತ Ramaya says like this.
Correct, and
Hey,
the
Ramaya.
court shall have the power to supervise and the carrying out of the compromise or arrangement.
on,
Therefore, that perhaps may not,
No, of course.
at what stage may not.
on merits of the application, my lord.
ಅಲ್ಲ ಆ ಪ್ರಶ್ನೆ
ಅದಕ್ಕೆ.
ಬರುತ್ತೆ ರೀ.
Please, my lord.
ನೋಡೋಣ ಅದು mostly we do not know.
Because, my lord, lot of applications and other things are connected with this.
You reserve,
Between that,
you reserve your right.
Till we
Till
decide
this is
this matter.
decided.
That is the best way.
8 years is the pendency of the appeal itself. OSA is pending since 2016.
But in that you maintain distance from Mr. Wilgold and Mr. Shankar also.
please.
Or you don't, you want to be untouchable to both of them?
No,
Or they treat you as a very bad word to use, untouchable.
No, it should not echo
Very bad
anybody.
thing. Huh?
It should not echo anybody. EPHO.
No, we are saying about the proceedings.
His,
that way.
his version is on the ground that the
There
scheme is there.
Ah, correct.
If the scheme is not there,
Nothing there.
Nothing survives for consideration.
so you go under the premise that the scheme is there or scheme is not there.
My lord, scheme is there.
but You want the scheme to be there?
No, my lord.
And on a lighter note, he has to come this stage.
So it is not
You have
about,
to change your side.
it is not about
Which
changing the
lawyers are
side.
entitled to do.
My lord, the assurance, my lord, the entire application that I have filed, my lord, section 391 of Companies Act, my lord, when a propounder proposes a scheme before the company court, my lord, the law says, my lord, that 3/4 majority of the members and creditors permission has to be taken, meeting have to be held. And thereafter, my lord, ultimate veto power is given to the company court to see as to whether the scheme is valid or not, or whether it is in the interest of the companies or not. My lord, at that point of time, the entire process, how it takes is, after the meeting is held, it is not just because majority of them hold that that scheme has to be sanctioned, it will be sanctioned. Various stakeholders
Need to be consulted.
they will be consulted. Here also, my lord, official liquidator was consulted. Regional director, that is ROC.
ಅಲ್ಲ ಕರೆಕ್ಟ್
company
ಬಟ್
was-
ಆ ಸ್ಟೇಜಿಗೆ ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜೇ ಇಲ್ಲ ಅಂತ ನಾವ್ ಅನ್ಕೊಳ್ಳೋದು.
ಹಾ. ಅಲ್ಲ
ಈಗ ನಿಮ್ದು ಸಪರೇಟ್ ಇಡೋಣ.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಇದರ ರಿಸಲ್ಟ್ ಮೇಲೆ ದೆನ್ ವಿಲ್ ಡಿಸೈಡ್.
Yes, ma'am. I think that's an appropriate.
If you have to say on this anything,
ಇವ್ರ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮೇಲೆ ಏನಾರ ಹೇಳೋದಿದ್ರೆ ಯು ಕ್ಯಾನ್.
ಸ್ಕೀಮ್ ಬೇಕು ಅಂತನ ಬೇಡ ಅಂತನ
ಅಥವಾ ಈ
ಮಾಡೇ ಇಲ್ಲ ಇವ್ರು.
ನಾನು ಚಾಲೆಂಜೇ ಮಾಡ್ಲಿಲ್ಲ. ಸ್ಕೀಮ್
Challenge ಮಾಡಿಲ್ಲ.
ಸ್ಕೀಮ್ ಇದ್ರು ಇವನ್ ದೆನ್ ಮೆಲೋಡ್ ದೇ ಹ್ಯಾವ್ ವೈಲೇಟೆಡ್ ದಿ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಸ್ಕೀಮ್.
Since you are there, we are asking you, do you want to sail in the ship of Mr. Shankar or in the ship of Mr. Huilgo?
Ship ಬೇಡ, boat he can't travel in riding two boats.
So I am on the side of appellant here only, my lord, but on the different premise. My lord, appellants are challenging, stating that opportunity is not given and other things. There are various undertakings given before this honorable court. Had those undertakings not given to this court, this honorable court would not have even granted that scheme. My lord, they said real estate business should not be done. It is the first most
Requirement of the
requirement,
scheme.
my lord, when they when a proposer proposes a scheme. The first question that is asked is whether you want to revive a company or you want that real estate immobile property which was there lying in the company. Everyone gives an assurance before this honorable court, no, we want to revive the company, you please sanction the scheme. After the scheme is sanctioned, they don't revive the scheme. They sell the property as if a real estate business. This is what we are challenging, and that, my lord, the power is there under section 392 of Companies Act, where, my lord, the company court has a jurisdiction to see as to whether the scheme is implemented. Even in this case, my lord, ROC, that is regional director, had filed an objection stating that this company, the proposer has no intention to revive the company. He wants to sell the property. That's why he is making this proposition. The even official liquidator made the same observation. For them, both of them, they filed an affidavit before this honorable court stating that we are not into real estate business. We want to revive this company. We want to set up a factory and restart the manufacturing unit. That is the affidavit which, my lord, what they have filed, I have produced before this honorable court. My lord, ultimately the order where your lordships have pointed out, my lord, that there are various objections and that observations, there is for no further objections. It is those objections for which affidavit which is filed by the proposer, which is accepted by the court on the face of it, stating that he has all intentions to revive the company. After the company is revived, after this order is passed, my lord, now we are in the year 2024, my lord, he has sold part of the land in favor of other person.
Therefore, you support Mr. Shankar.
Please, my lord.
But understood. Aste.
Yes. Now, just some brief background fact. The first order, Malaz, was passed on 27/7/2006. Malaz will find that order at page 122. Kindly see page 141. Appeal. There were number of company petitions filed, Malaz, for winding up. One was a reference made by the BIFR itself. Some
Anyway,
creditors-
Justice Bopanna have said, one petition is sufficient,
Correct.
which is allowed, and rest of the petitions
Absolutely.
go anta, observation.
Yes,
there.
no. So the
I
first
read
winding
somewhere.
up, just to point out the facts,
Yes.
page 141, Malaz may kindly see, there was a direction of the learned single judge to wind up the company. Now, against that, your lordship saw Justice Gopal Gowda's order, which starts at page 143.
No, this order is
Set aside.
DB.
20,
order.
yes, that's right. Madam. Division bench order. Your lordships will find the relevant observations at page 154,
154.
154. Therefore, on this ground alone, the impugned winding up order.
You asked us to read 130, 142,
That's right, Madam.
41.
141 and 142.
Correct.
Correct, Madam. That was the first winding up order, where the company, that is Shrishma Chemicals, was directed to be wound up. May I just read paragraph at page 141, the unnumbered, second unnumbered paragraph. Page 141.
First order of Justice Sabhai, senior
That's right.
Sabhai.
This is.
No, VG Sabhai.
That's right. This is VG Sabhats.
You are right.
Company petition number so and so. is
Others
allowed.
are dismissed because the one
Because
petition
any,
is allowed.
any event, that's right. Madam. That's all.
Understood.
That's all that happens. Then your lordships may kindly see the order starting at page 143, which was, kindly see the appellant. This is the same union that Mr. Shankar represents today. Page 143, the relevant observations at page 154.
154.
Therefore, on this ground alone, the impugned winding up order, 154.
That DB order.
Correct, Manoj. The division bench finds fault with the learned single judge in not hearing the union before passing the order.
So remitted the matter
Admitted the
for
matter back.
reconsideration.
That's right. So therefore, the winding up order was set aside.
What is the significance of this?
Because the original winding up order was recalled. So therefore, a company that was ordered to be wound up no longer was directed to be wound up, and the matter was restored before the single judge. That led to Justice Bopanna's order, my lords. You'll find at page 155.
But he also directs winding up.
Once again, no, there are some relevant observations there, my lords, which are which your lordships may kindly take note of. At paragraph 3, page 157.
By 7, having heard.
That's it. Having heard the learned counsel appearing for the rival parties, the subsequent position which is evident is that the learned counsel representing the employees union and the staff members had an opportunity to put forth their contentions, but they have not put forth any scheme before this court whereby the company can be kept afloat. In the meanwhile, during the pendency of these petitions, the assignee of the secured creditors filed an application under section 391, praying this court for a direction to convene meeting of shareholders. Again, may not be relevant. Again, facts will get murkier here. What happened
you
is
want
there
to
was
say
another
is
scheme.
they did not provide anything
That's right. To keep, no scheme was propounded by
proposed
them
by the
to
employees.
keep the company afloat. Because the main premise on which the company petition was restored was that the employees ought to have been heard. Why should they have been heard?
Because they can
Because
say
they could-
something.
To keep the company afloat. Then the learned single judge notes, you have not put forward any scheme. Therefore, finally, just a couple of relevant paras before that, before the order of winding up again. Page 160, paragraph 5. ಇಲ್ಲ ನಮ್ದ್ರಲ್ಲೂ ಹಾಗೆ ಇದೆ ನಮ್ದ್ರಲ್ಲೂ ಹಾಗೆ ಸ್ವಲ್ಪ ವಾಯ್ಪು ನಾನು ಸ್ವಲ್ಪ ಏನೋ page 160 at paragraph 5. I'm not sure.
Full print
ಅದೇ
ಆಗಿಲ್ಲ.
ನಮ್ದ್ರಲ್ಲೂ ಹಾಗೆ ಇದೆ. That's why I've just I'll try to fill in the blanks.
Okay.
It is to be noted that the employees union had also demanded with regard to certain arrears payable to them.
One second. We'll just complete our sentences, words also here.
Demanded.
Demanded.
Is what I feel that
Huh.
with regard to certain arrears payable to them, regarding which, that I think next this is regarding which the applications have been filed under section 33C2 of the Industrial Disputes Act, and the same were pending.
You are right.
Ultimately, in the process of winding up, not only the workmen,
UP and not. ಎರಡನ್ನ ಹಾಕೋಬೇಕಾ?
In the process, UP and not, correct. In the process of winding up, not only the workmen,
All creditors are.
all other creditors who are entitled to receive the amount would be in a position to make their claim before the OL. When the claims are invited, the interest of all parties would be protected. So the grievance really then of the employees union was that certain arrears have not been paid, for which applications have been filed under the Industrial Disputes Act. What the learned single judge says is subject to the proceedings under 33C2, you can always make a claim before the OL as and when they're adjudicated, of course, because the adjudication has to be done by the labor code.
33C2 has to be done by the labor court.
Of course.
That order they will carry it to the OL.
To carry it to the OL.
OL will treat that order on pari passu basis.
Absolutely.
Okay.
That's where 529A will have to
That's
be invoked.
Understood.
Then, my lords, at para 6, once again, the reference made by BIFR is accepted and company is ordered to be wound up. Then in the meantime, my lords may kindly see page 167 now. That is when a project proponent called SDV Ironworks enters the fray.
Why this company suffered so many winding up orders and still it is not wound up, still it
Wound up / revived also.
Revived
Because of this litigation, now they're in the twilight zone.
Okay.
And this is the order at 167, 19/11/2013, wherein, my lords, kindly see at page 168, the learned single judge notes what the application is all about. The present application filed by assignee of the secured creditors to convene a meeting of the shareholders, debenture holders, secured and unsecured creditors for consideration of the scheme of arrangement for revival of Messrs. So-and-so, which is in liquidation. Now kindly see, my lords, page 170.
This is a post liquidation order.
To revive the company. So the scheme, my lords, is the scheme of the act is that if a company is ordered to be
This application is moved by,
SDV Ironworks,
who are they?
they are respondent number 6 in the appeal.
No, how they stand?
They
Bought the shares.
correct, but they are an assignee, in fact, assignee of the secured creditors, not the shares, my lords. They are assignee of some of the secured creditors. They were creditors, my lords, who may have assigned their debt or assigned their loans to this person.
This is where they said it does not amount to transfer within this, it was this. No.
That was long ago. That may not be relevant at all.
Relevant at all.
That may not be relevant at all.
Okay.
So suffice to say, my lords, now what the learned single judge did in this is that you have now come forward and said, please convene a meeting of all the shareholders, debenture holders, creditors, and so on. At page 170, that meeting is directed to be convened. Kindly see page 170. For the reason stated, the application is allowed. The meeting shall be convened on so-and-so date. Insofar as the shareholders are concerned, the meeting shall be at so-and-so time. The venue of the meeting is also fixed. Chairman of the meeting shall be so-and-so advocate. Quorum of the meetings for shareholders shall be 5 persons by person, by proxy, and so on. So that meeting is directed to be convened. This application was only to convene a meeting to see if all the heads can be put together to revive this company. So the meeting is directed to
Post winding up order.
post winding up, pre-revival. So this is only, there are various interested parties, including creditors, debenture holders, shareholders. The learned single judge said, all of you please sit together.
If possible, revive.
Possible,
To keep
please come up
the
with a
ship
scheme
afloat.
to keep the ship afloat, if possible. If there was no consensus at the meeting, the liquidation proceedings will continue.
Understood.
Now that meeting was convened on 23rd January as directed by the learned single judge. Kindly see the report, my lords, at page 173.
What report said? Chairman's report.
Chairman's report, my lords. This is quite detailed. I'll just read out some of the relevant portions. At page 174, my lords, meeting of equity shareholders, paragraph 1. At clause D, 1D, 72 shareholders attended the meeting. Total number of votes was polled at so-and-so. Out of this, 33 members so-and-so cast their votes against the resolution, and 39 members.
So they proposed a scheme for
They
year.
proposed. So that was the shareholders. Similarly, 2D, debenture holders also. Therefore, the scheme was unanimously approved. My lords will find last but one sentence at 2D.
Therefore, the
Shareholders
scheme was unanimously approved.
approved by debenture holders. Similarly, unsecured creditors, or if my lords were to turn over the page, 176. Again, last sentence. The meeting of the unsecured creditors of, my lords, has it 176? This is for unsecured creditors.
This unsecured creditors.
The last sentence, about 5 lines from the, this is once again 3.
The meeting of the secured creditors
Correct. Meeting of the
of
unsecured creditors
Shrishma Fine Chemicals.
approved the scheme of arrangement without modifications. Resolution was
As it is, it is
as
approved.
it is, it was approved. Similarly,
These are unsecured creditors.
unsecured.
But they are treated, the company, the workmen are treated as secured creditors only.
No, they're not.
They
In
are
fact,
not.
that is also taken
Just
note of by
pari
the
passu.
chairman. They're just as claimants, but they were not, in all fairness, my lords, the chairman also notes that they were not permitted to attend this meeting because the learned single judge did not direct so. Kindly see at 4C, I'll just come to that.
Justice Bopana Sab's order you are referring to,
Justice Anand Baira Reddy's order, which my lords will
which directed, but specified the date of meeting
Correct.
and these are the persons who should appear.
yes, yes, that's right. At page
That
1,
did not allow the
that did not
workmen at all.
That did not allow.
Okay.
And that is taken note of at paragraph. Just before that, my lords, we kindly see meeting of secured creditors at 4C. Meeting of the secured creditors. Once again, the scheme of arrangement without modification was
Correct.
passed unanimously.
Correct.
And then note, the office bearers of the union wanted to attend the meeting of the unsecured creditors, which was not permitted by me as they were not the unsecured creditors of the company as per the available records. They issued a letter dated 23/1/2014 to me, which I have annexed to this annexuary. Now, what the chairman says is this. To be an unsecured creditor, it is predicated on the fact that there is a claim. Now, my lords noted in Justice Bopana's order, his lordships noted that a claim is pending under 33C2. Now, armed with that, as your lordships pointed out, armed with that, they could have made a claim, in which case they could have been treated as unsecured creditors, which is why the chairman notes, I cannot allow you as an unsecured creditor because you don't have anything to show that you are an unsecured creditor. So which is what the chairman seems to note.
There was one judgment of the apex court, I don't remember, some Ramakrishna Menon, something like
Yes,
that, which gave a role to the workmen.
Yes, ma'am.
Do you have that judgment?
No, ma'am, I'm not. I'll just check. I'll do my, I'll just.
Can, whether our, ನಮ್ಮ researcher.
No, on what issue, ma'am, we'll immediately check. We'll immediately check.
It will have relevance. The apex court said, I think 1980s decision it is.
Yes.
We were told in law school by Professor Vishwesharaya, great teacher, recently passed away. He used to tell us, Ramakrishna Raju or Ramakrishna Menon versus so and so, 80s judgment, where the apex court mentioned about the status of workmen and their trade union
Yes.
in winding up proceedings.
Proceedings.
It was essentially a winding up. Can you Google out that judgment?
Yes, ma'am. He's checking immediately, ma'am. No, we will check it immediately.
I may be wrong also. I'm from a vague
No,
memory.
no,
I have-
very
I'm
rarely,
saying
but
that
yes.
one, but there was such a judgment. I read that. Very often, my
National Textile Workers versus PR Ramakrishnan. That is.
PR Ramakrishna.
Justice Bhagwati, ma'am, Constitution
Correct.
bench.
Bhagavati Justice judgment.
We'll just check that. I'll just check if it has
Yeah,
any bearing.
Just take out that judgment.
I'll just,
It answers, it throws light at least on the issue.
yes, ma'am. I'll address that. If
84 judgment.
1982.
82, maybe.
82.
Yes.
So this is where, my lords, as per the direction of the learned single judge, meeting was convened of the debenture holders, shareholders, secured and unsecured creditors.
And
All
they
of
were
them-
treated not as unsecured
Yes.
creditors.
And
at
so
all.
they were not, there was no separate meeting convened for them, nor were they permitted to attend the
By the
meeting.
company court itself.
Yes, ma'am. So at page 170, what the learned single judge notes is,
You have read it, no?
yes, ma'am. of
You
course,
said,
I've read it.
you have read that. I remember.
So the next step, what happens is after this report is placed before the learned single judge, and my lords may kindly come to page 28, which is the impugned order. Page 28.
Page 28. No, you were reading chairman's report. Only note you wanted
That
to
note.
highlight.
That's all.
Why they were not permitted.
Why they were not permitted. So it's not as if the
But,
chairman.
Does it accord with the labor jurisprudence, coupled company jurisprudence also?
Yes, ma'am. No, the way I would put it, my lords, subject to correction is, if I have to go with the claim, let us say, my lords, a simple money recovery suit, I should have a decree in my favor to make a claim. But I cannot go without a decree in my favor and say, I am owed 1 crore rupees, please allow me. So it is precisely what, in that case, I'll be treated as an unsecured creditor. So in this case, if any employees have to make a claim, they may have a valid claim, but they have to make that claim before the appropriate forum, in which case, in this case, it's the labor court. And armed with that order, they can make a claim in the winding up proceedings.
33C2 order.
That's right, 33C2 order.
But once 33C2 order is made, they become secured creditors only.
They may, that's a different, yes, ma'am. They may become,
Anyway, that question may not
that
arise.
question may not.
As long
arise.
as 33C2 is pending
Correct.
before the labor court.
Yes, ma'am.
So long they assume the status of unsecured creditors.
Yes, ma'am.
Input 11
Possibly that's a view that can be taken. Correct.
Who
No, I'll
are
come-
in matters like this?
Yes.
How Companies Act says who should be heard, who should not be heard in these matters? What Ramaya says, hey Ramaya, or Chalmers company law, na, the famous
Yes, ma'am, correct.
Chalmers company law, English company law. How they say?
I think the general I'm subject to correction again, Malas. General jurisprudence is that anybody who has an interest in the company, who has any claim against the company, ought to be heard. Otherwise, nobody can, any order for, say, winding up or any order for revival, if it affects me, I certainly have to be heard. But which is correct, of course. That's predicated on the principles of natural justice itself. But I'll just check also, Samit will just check if the Companies Act itself says anything.
But anyway, one point will be,
That's okay.
the company court did not say, but company court in so many words said who should be permitted to
Secured
participate in
creditors,
the
unsecured creditors, shareholders, debenture holders. So to get a foothold in, they had
Whether they were party there, where that observation was made,
before
were they
the,
parties there?
no,
They were not.
no, because that was a scheme.
So Mr.
propounded by-
Shankar will say, at least we can be unsecured creditor. We should, ought to have been.
I'll
heard
come
in
to
that.
that. I'll come. Even then, again, as I was saying, the most important aspect is even as of today, even fast forwarding 8 years or 9 years down the line, even as of today, there is no adjudication by any industrial tribunal or labor court in their favor saying that this is the exact amount of arrears.
What happened to 33C2?
That got rejected. That was
That got rejected.
that was rejected. That came to be rejected, Maharaj. Then the matter, it was taken up before this honorable court.
Just give us the date on rejection of
Yes, sir.
33C2.
Can I just point, there's one memo with, just give me that. I'll just, this is the, correct, absolutely. That was called in question. That was called in question.
What happened to that?
I'll just point it out. Just show me the relevant page. Now, what you have given, court. Copy, definitely. Just give one copy to Rajat. Page 33, my lords, of that compilation. Sorry?
33 of.
I think they have given the wrong.
This one.
I'm so sorry, that's the wrong one. The compilation is here. I'm so sorry.
ಏನಾಯ್ತು ಅಂತ ಹೇಳ್ಬಿಡಿ ಅದೇನು
I'll just read out the relevant type.
ಅಲ್ಲ ವೆದರ್ ಇಟ್ ವಾಸ್ ಸೆಟ್ ಅಸೈಡ್ ಅಲೋಡ್ ಇಷ್ಟಕ್ಕೆ ನಿಲ್ತು 33
These petitions were
ರಿಜೆಕ್ಟೆಡ್ ಬೈ ದ ಲೇಬರ್ ಕೋರ್ಟ್
sent back.
ಚಾಲೆಂಜ್ಡ್ ಬಿಫೋರ್ ದಿ ಹೈ ಕೋರ್ಟ್ ವಾಟ್ ಹ್ಯಾಪನ್ಡ್ ಬಿಫೋರ್ ದಿ
It was set aside and once again the petition
ರಿಮೈಂಡೆಡ್
remanded.
and after remand what happened?
They have not gone back at all. They were supposed to go back and file an application once again. That application is, I'm told, Malas, even today, not even filed. Kindly see, well, that was affirmed by the division bench.
Where is the order? Let us see the text
Page,
of the order.
Page 87. Kindly see page 86, Malas, para 16.
86. Though the prayer.
Correct. Though the prayer made in the application filed under 33C2 is omnibus, such prayer cannot be granted and the entitlement of the workman, if any, would have to be restricted to such money or benefits to which they are entitled to and being capable of computation in terms of money. In view of the fact that there is no transfer of undertaking as discussed herein above, the workmen would be entitled to full wages from the day they have been prevented to discharge their duties, that is 27/4/1994, as also minimum bonus for the years 92, 93 and 94, and subject to an order of retrenchment being held to be illegal in appropriate proceedings as observed herein above. In view of the fact that there being no transfer of management of respondent number 1 company.
Transfer compensation illa.
Illa, that's right.
ಆಮೇಲೆ
Therefore,
wages ಅನ್ನ ಮತ್ತು
writ
bonus
petitions are
ಅನ್ನ
allowed.
claim ಮಾಡಬಹುದು.
Now kindly see. Correct. One second.
Again, they have to file claim petition. Because their earlier claim petition was 33C2 was on the premise that there was transfer.
That's right.
Therefore, transfer compensation has to be
That's
paid.
right. Now that was affirmed by the division bench, my lords, at the next page, page 89.
Okay.
Application is filed to the commissioner, it is registered, it came up to WP 1114 and back.
No, that application is before the labor court.
How the labor court-
33C2.
Commissioner passed an order, that was called in question, WP 1114 and that is.
Which commissioner passed the order?
What is
The
it?
commissioner.
No, 33C2 is a labor court jurisdiction.
The reference was made by taking this up.
No reference is required
No, no,
for
no.
33C2.
It is done wrongly and that's why it's pending in the high court. What was WP 1114? Beloved, this is.
ತೋರಿಸಿ, all right, ನೀವು ಹೇಳಿದ್ದನ್ನ ತೋರಿಸಿ ಏನಾಗಿದೆ ಅಂತ from records. That cannot be because two judgments of this court say 33C2 is the matter for labor court and not the commissioner at all.
Special jurisdiction.
And one matter is argued by your Subra only. In whose steads you want to stand now?
No, just before that, my lords, now, despite the liberty being reserved by the learned single judge, rather than going back to the labor court, they challenge it in a writ appeal. Your lordships will
No,
find.
that also dismissed. Na,
Correct,
Kinigi
ma'am.
Saab
I just,
and,
I kindly see
RRS Saab, you say.
some observations at page 128.
120.
Labor matters, Parkinson's law applies. Multiply, one for proceeding becomes 10 proceedings. That's how they pending again.
We did not catch the point.
He's still not dead, he's still alive. The proceedings before the labor court are 3332, after remand, that
Where
application.
is the remand?
ಇಲ್ಲಿಂದ ರಿವಾಯ್ತಲ್ಲ just.
No, that was not a remand.
No, you
They
are-
only permitted you to file it.
Liberty was.
Liberty.
Liberty
It's
is
not a
availed.
case. Therefore, we wanted to ascertain, he is right in saying there is no remand at all. There could not have been remand because your 33C2 was
Premise was
structured
different.
on a premise that the share, transfer of share amounts to transfer of industrial undertaking. That the court did not agree.
Could my lord just see some relevant observation of the division bench in the writ appeal, page 126, my lords? Can I just read paragraph 3?
Impugned order of
Impugned order of the learned single judge was passed to 31/1/2012. Therefore, writ appeal which was filed, thereafter review petition was filed. Detailed order was passed by the learned single judge while dismissing the review petition. On 13/2/2015, application was filed by the appellants under section 33C1 before the Labour Commissioner. During the pendency of the application, the instant appeals were filed on 28/4/16. Agreed by the order dated 6/12/16, the order was passed by the Deputy Labour Commissioner. On considering the reasons assigned, we do not think that the same constitutes sufficient cause. The reason assigned by the appellants is that the appellants being workmen were spread out and could not come together to file the writ appeals on time, cannot be accepted in view of the series of litigations initiated by them. Much after disposal of the writ petition, they have filed the writ appeals as well as the review petition and the application under 33C1 before the Labour Commissioner. Therefore, it cannot be said that the appellants were scattered.
C2 Allah.
ಇಲ್ಲ 3C1 ಕೆಳಗಡೆ Labour Commissioner ಗೆ ಹೋಗಿದೆ.
It was not 33C.
Yeah, that application is filed. It's already the pending.
Correct.
Can you tell? This application under 33C1.
I'll just check.
Then application is filed before the
Then
Labour
the
Commissioner.
last page, my lords, this is, I'm sorry, this also.
128.
Correct, miss. That's right, miss. 128, once again, then to contend that they could not come together, so on, so, and the writ appeal is dismissed. And finally, even on merits, last sentence.
Even on merits, we do not find any ground to
interfere with the order
interfere.
passed by the learned single judge under these circumstances in view of the absence of sufficient cause. Consequently, appeals stand rejected. Now, next page, my lords may kindly see page 130, which is an endorsement issued by the Pitadhikari Karmika Ilakhe. So,
Yeah.
Yes.
so here again, my lords, kindly see for the various reasons,
Endorsement.
ಈ ಮೇಲ್ಕಂಡ ಕಾರಣಗಳಿಂದಾಗಿ so and so ಕಾರ್ಮಿಕ ಸಂಘದವರಿಗೆ ಕೈಗಾರಿಕಾ
2022.
22, 19 to 20.
Matter is still pending.
Against.
ಇದ್ಯಾವುದು ಮಾನ್ಯ ನಂಬರ್ 3.
Yes, my lords, ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಬೆಂಗಳೂರು ಪೀಠವು
WP
ಪ್ರಕರಣ
so and
so
so.
and so
Perhaps that was
that is
transfer.
Arvind Kumar's order. That's it. 4513 of 2004 ಅಲ್ಲಿ ಎರಡನೇ ಅಪರ ಕಾರ್ಮಿಕರು ಹೊರಡಿಸಿದ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಲಿದೆ.
So he did not agree to refer the
Correct.
matter for industrial dispute
Correct.
purpose.
Correct.
to the government.
Yes,
One clarification, that order is passed. The matter went up to the Deputy Labour Commissioner and an endorsement was issued by Government of Karnataka on 19/2/2022. That matter is in WP 1144/22 pending before this honorable. That after that, I used the word remand, my lord uttered liberty given, availing the liberty, an application was filed before the Labour Commissioner. Deputy Labour Commissioner decided the matter. Again, that writ petition is filed by Mr. Subra's office and it is pending in WP 11442 of 2022. That's why I said Parkinson's law. 1 becomes 10, 10 becomes 100.
No, may I submit this? Now, of course, that endorsement,
ಅಲ್ಲ,
I wasn't aware that.
retrenchment, whether that also needs espousal. No,
No.
straightway they could have filed that.
Yes, ma'am,
It's an
that's
industrial.
what I believe. That's an industrial dispute. Madam, under
Retrenchment also
schedule-
is an industrial
Correct.
dispute.
Yes, madam. It is. In any event, of course, madam, for today's purpose now, what if to coming back to what the impugned order is. Now, all of this is
Further.
parallelly.
We agree with you,
Yes,
not for that.
No, no, of course,
We
it's my
wanted
duty.
to know the conduct of the party. If their case is that there is retrenchment,
Correct.
wrongful retrenchment, that's an industrial dispute under
Dispute.
section 2. Yes, sir, ಅದು.
Yes, yes.
Yes, sir, 2, yes. Industrial dispute ಆಗ್ತದೆ ಅದು. Why they needed reference, all these things, that we wanted to
No,
know.
in fact, the learned single judge, my lords, if again, Justice Arvind Kumar's order very clearly says, I'm not sure, petitioners would be entitled to file application to 33C2.
That's what.
So it's very clear. And seek computation of the money or amount due to them with effect from so and so. In the event adjudicating, competent court adjudicating and holding that retrenchment is illegal in a dispute raised under section 10(1)(d). That's what.
ಈಗ ನಿಮ್ಗ ಅವರು ಏನಾದ್ರು ಇದ್ರ ಕಾಂಪ್ರಮೈಸ್ ಎಲ್ಲ ಸಾಧ್ಯ ಇಲ್ಲ?
In fact, I'll just point out, kindly see the after, I'll just finish off the narration of fact.
After all, they need.
Compromise agide, we've given an undertaking. One of the orders that are under challenge before your lordships against the order according approval to the scheme of arrangement, a review petition was filed by the union. That review petition was disposed of, recording or undertaking that whoever is available, we will take them for if there is any need, we will take them. Kindly see, my lords. Now,
ಬಹಳ ವರ್ಷದ ಹಿಂದಿಂದ ಇದು.
of course, 2015 order. Kindly see, I'll just complete the narration of events. Page 28.
28.
Yes.
Beraredi Sahibrdu.
Correct. That's right. That's it. Kindly see at page 33, the 33, my lords, just to give. No. No, I'm reading this. Kindly see page 33, my lords. The proposed scheme of arrangement filed by the petitioner seeking revival of the company in liquidation contains clause 10 of the scheme of arrangement. Now, this is something to do with that KIDB. I'll come to that. In fact, your lordship sitting single subsequently directed KIDB to execute the sale deed. But here, one of the main.
Same matter.
Same company.
We made the order.
Not the.
That will not disable me from taking the matter.
No,
I'm just asking you. I don't
know. I don't think so. So anyway, that was a bone of contention as to whether a clause in the scheme of arrangement mandating a state undertaking like the KIDB to execute a sale deed could be included. Now, the learned single judge said, no, I cannot approve this scheme of arrangement which mandates KIDB to execute a sale deed. Therefore, delete that clause. So after that clause was deleted, the scheme of arrangement was approved. Now that, my lords, will find at pages 36 and 37.
ಅಲ್ಲ ಅದು ನನ್ನ ಆರ್ಡರ್ ಇಲ್ಲಿ ಏನು ಅಪೀಲ್ ಗಿಪೀಲ್ ಆಗ್ಲಿಲ್ಲ ಅದ್ರ ಮೇಲೆ?
ಅಪೀಲ್ ಹಾಕಿದ್ರ? ಇಲ್ಲ. They executed the sale deed also. KIDB is accepted.
But that has nothing to do with the merits of the matter. That may benefit Mr. Shankar in the event he succeeds also.
So in effect, now this order, what happened is the winding up order that was passed by Justice Bopanna finally came to be recalled. Now that, my lords, will find at page 37.
Correct.
The winding up order dated so and so is recalled. Official liquidator is directed to hand over possession of books of account and also movable and immovable property.
The company is
now revived.
We can't say revived because it's not ordered to be wound
as
up
per this.
And not wound up.
Correct.
That's the legal
position. That's right. Absolutely correct. Absolutely right. And now, as per the scheme of arrangement, which was unanimously approved by secured and unsecured creditors, debenture holders, and all the stakeholders. So therefore, the winding up order was recalled. Now, against this order,
review petition was.
So kindly see, there's just one paragraph Mr. Samit wants me to point out, at page 38. All other reports filed by the OL and the applications become infructuous and are accordingly disposed of. The OL claims that there are further charges towards security services which the learned counsel undertakes to pay on demand.
Yen hangandre? What is meant by that?
I'm told, my lord, they had filed a report and saying that they should not be used in real estate business and so on. Therefore, at page 38, the learned single judge says all other reports have become infructuous. Now that the scheme of arrangement has
so you can enter into real estate business and
only for the purpose of saying that those reports become infructuous.
Idr bagge.
At that point of time, liquidation was pending. Official liquidator had also filed an application to sell the assets of the
company.
All those applications were pending.
Fair enough.
Because of revival, my lord, those applications got
rendered infructuous.
Not the other application where observation was made saying that what propounded
generally
that remains intact. That is what you wanted in your petition. Correct.
Against that order, a review petition was filed. My lords has it at page 39.
And that was negative.
That's right, page 39. Now,
Last
that
five,
order,
6 lines, last 6
Correct,
lines over
boss.
there,
Page
43.
that's right. Shri so-and-so on this would submit that if such applications are made and if they are qualified workmen, the company would not be averse to considering their case for employment. Recording these submissions, the review petition stands disposed of. And also one more paragraph before that, at page 42.
Alla, idnadru, did you follow this order at least?
One minute,
Yeah,
my lord. While your lordships are at page 42 and 43, kindly notice, we have not been heard. Only Kasturi is heard. Learned senior advocate Kasturi on instructions from the company would submit that the petitions are before this court without their being claim adjudicated by the competent court. There is no, we have not been heard. This is the
You
review
were-
petition which is
One
filed.
nimsh.
And
you were-
that's one of the grounds we have raised.
Yeah, but
Were
page
not
43,
heard,
ಮೇಲ್-
were you party to this?
they were the applicants.
You were the applicant.
ಇಲ್ಲ, page 43, right on top, my lords. The learned senior
It's
advocate.
union only.
Yes.
What is meant by you were not heard in the matter? When Kasturi said that, you should have said, we are not agreeable to this.
ಇಲ್ಲ, ಮೇಲ್ಗಡೆ, in fact, to the contrary,
Subrao would make it say in the last paragraph.
Mr. Narayan Bhatt appeared for Messr Subrav and Company.
ಇಲ್ಲ
I-
Subrao
Page 43 note, one
ಇದೆ
then.
Subrao ಇದೆ next page.
page 43, right on top, my lords. That should
Subrao's name comes
clarify.
Adnet senior advocate Sri Subrav would, however,
submit that
he himself had appeared.
the record wise. Yes.
Mathinnenu.
ಅದೇ
Record should be
No.
believed.
contention ನೋಡಿ, which are capable of rendering useful service to the respondent company, and they should be permitted to make their application for seeking this is not the purpose of review. Review is
But what you have argued before the judges will decide that. Whatever you have urged in the review petition,
there are-
that learned judge treated it. ನೀವು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ದಲ್ಲಿ ಏನಾರ ಇರ್ಬೋದು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ನೀವೇನ್ ಹೇಳ್ತೀರಿ? ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಸ್ ದ ಫ್ಯಾಕ್ಟರ್ ನಮಗೆ.
ಇದ್ರೊಳಗೆ ನಮ್ಮ ರೀಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ, ಅದು ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ. ಸೊ ಕಸ್ತೂರಿ says, if they are-
ಕೊಡ್ತೀರೇನ್ರಿ? ರೀಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡ್ತೀರಾ?
That's our solemn undertaking, my lords. We can't renege on that.
ಎಷ್ಟು ಜನ ಇದ್ದೀರಿ ನೀವು? ಕರೀರಿ.
Whoever is
ಎಷ್ಟೆಲ್ಲ
eligible,
argument
certainly,
ಗೆ
my lords.
ನಿಮ್ಗೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ನಿಮ್ಗೆ ಒಂದೆರಡು ನಾನು ಗೋಟ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಲಾಸ್ಟ್ ಅಂಡ್ ದೇರ್ ಫಾರ್ ಐ ಶುಡ್ ಬಿ ರಿಸ್ಟೋರ್ಡ್ ಅಂತ ಅನ್ಕೊಂಡಿದೆ.
people are there.
ಕೊಡ್ಸಿದ್ ಇದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾಗತ್ತೆ.
150 people are there.
150 people. ಇದನ್ನ ಮಾಡಿದಾಗ ನಿಮ್ಮ ಅಸೋಸಿಯೇಷನ್, ನಿಮ್ಮ ಟ್ರೇಡ್ ಯೂನಿಯನ್ ಮೆಂಬರ್ಸ್ ಎಷ್ಟು ಜನ ಇದೆ ಅಂತ ಕೇಳ್ರಿ ಅವ್ರಿಗೆ.
If they are eligible, my lords, we're still, I mean, this is an undertaking given by the council, so
That's what.
150.
You can't say no also.
say no, can't say.
All 150 are trade union members.
ಏಜ್ ಏನೇನಾಗಿದೆ ಅವರಿಗೆ?
That is
ಎಷ್ಟು ಜನರು ಏಜ್ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಅಟೆಂಡ್ ಮಾಡಿದ್ದಾರೆ?
ಒಂದು 15 ಜನ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಬಂದಿದ್ದಾರೆ.
15 ಜನ. 150 ಒಟ್ಟು ಸಂಖ್ಯೆ ಎಷ್ಟು?
135
150ರಲ್ಲಿ
Total
15 ಆದ್ರೆ 135. ಹಾ,
232 ಜನ ಒಟ್ಟಿಗೆ ಇದ್ದಿದ್ದು ಸರ್. ಅದರಲ್ಲಿ ಸ್ಟಾಫ್, ಆಫೀಸ್ ಸ್ಟಾಫ್ ಮತ್ತೆ ಸೂಪರ್ವೈಸರ್ಸ್ ಸಪರೇಟ್ ಸರ್. ಟೋಟಲ್ ಅದ್ರಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ 173 ಜನ ನಾವು ಎಂಪ್ಲಾಯೀಸ್.
ನಿಮ್ದ ನಿಮ್ದ ಲಿಸ್ಟ್ ಏನೋ ಇರುತ್ತಲ್ಲ, ರಿಜಿಸ್ಟರ್ಡ್ ಟ್ರೇಡ್ ಯೂನಿಯನ್ ಇದು ಲಿಸ್ಟ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಯಾರು ಇದ್ದಾರೆ ಅವರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡಿ. ನೀವು ಯು ಹ್ಯಾವ್ ಗಿವನ್ ದಟ್ ಇಂಪ್ರೆಷನ್ ಟು ದ ಕೋರ್ಟ್.
That undertaking is there, but we
ಕೊಡಿ
can't,
ಮತ್ತೆ
there is
ಅವ್ರಿಗೆ
no
ಎಂಪ್ಲಾಯ್ಮೆಂಟ್
question of.
ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿದ ಹೊತ್ತು. ಉಳಿದಿದ್ದೆಲ್ಲ ಕೇಳ್ರಿ ನೀವೇನ್ರಿ? ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಮುಗಿದ ಹೊತ್ತು ನಿಮಗೆ. ಬೇರೆ ಏನಾರ ಬೇಕೋ?
ಸ್ವಾಮಿ ನಾವು 4 ಸಲ ಹೋಗಿ ಅಪ್ರೋಚ್.
ಆಲ್ ರೈಟ್, ಈಗ ಹೇಳ್ರಿ, ನಿಮಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಬೇಕು, ನಿಮ್ಮ ಜೀವನೋಪಾಯ ಆಗಬೇಕು, ಅಷ್ಟೇ ಕೇಸ್ ನಿಮ್ದು. ಏನ್ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕ್ರಿ?
and they are superannuating soon also.
ಏನ್ ನಮ್ಗೆ ಜುರಿಸ್ಪ್ರುಡೆನ್ಸ್ ಬರೆಸ್ಬಾಡ್ರಿ ನಮ್ಮ ಕೈಯಿಂದ. ಕ್ಲೈಂಟ್ಸಿಗೆ, ಲಿಟಿಗಂಟ್ಸಿಗೆ ಜಸ್ಟಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಓದ್ ತಗೊಂಡೇವಿ, ಆ ಪ್ರಕಾರ ಮಾಡ್ತೇವೆ ನಾವು. We have not taken oath to develop jurisprudence. ಅವ್ರಿಗೆ ಯಾವತ್ತು ಕೊಡ್ತೀರಿ? ನಿಮ್ಮ ನಾವು ಯಾವತ್ತು ಕೊಡ್ತೀರಿ ಅವ್ರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್?
Whoever is eligible, now.
ಅಲ್ಲ, ನಾವು ಇದನ್ನ ಪೆಂಡಿಂಗ್ ಇಡ್ತೇವೆ ಅಲ್ಲಿ ತನಕ.
No, certainly, I'm not saying disposed of, not at all.
ಈಗ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಮುಗೀತು.
That's all. So these are the two impugned orders.
ಆಲ್ ರೈಟ್.
So therefore, my lords, this,
ಹಾ,
and in view of the solemn undertaking, there is no question.
ಈಗಲೇ ಸಬ್ಮಿಟ್.
230 will have it.
2:30ಗೆ ಬೇರೆ ಆನರಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಜೊತೆ ಇದೆ. ನಾವು ವಿ ಹ್ಯಾವ್ ನೋ ಆಪ್ಷನ್.
Lordships have it next Monday, then in the meantime.
ಮತ್ತೆ ಹಿಂಗೆ ಎಷ್ಟು ವರ್ಷದಿಂದ ಇವ್ರು ಹಿಂಗೆ ಕಾಯ್ಕೋತ್ ಕೊಡಿ ಎಲ್ಲರೂ. ಈಗ 15 ಜನ ರಿಟೈರ್ ಆಗಿದೆ. ಒಂದು ಆ ರಿಟೈರ್ ಆದಂತ 15 ಜನರಿಗೆ ಏನ್ ಮಾಡ್ತೀರಿ? Because they retired, because you did not honor their demand. What are you going to do to those retired people?
List is here.
ಕೊಡ್ರಿ, ಲಿಸ್ಟ್ ಕೊಡ್ರಿ,
Oh, madam.
ಅವ್ರಿಗೆ ಕೊಡ್ರಿ. ನಿಮ್ಮ ನಿಮ್ಮ ಕಂಪನಿಯಿಂದ ಯಾರಾದ್ರೂ ಬಂದಾರ ಲೇಬರ್ಗೆ ಸಂಬಂಧಪಟ್ಟರು, ನಿಮ್ಮ ಲೇಬರ್ ವೆಲ್ಫೇರ್ ಆಫೀಸರ್ ಎಂತಾರ ಇರ್ತಾರಲ್ಲ,
So let them share the list.
One- one-
I'll show, I'm
That's
told,
all.
my lord, that no application was made, but even assuming that is true.
ಅವ್ರು ಕಳ್ಸಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ ಹತ್ತಿಗೆ ಲಿಸ್ಟ್ ಇತ್ತ
No, no, no,
ನೋಡಪ್ಪ
now
ಈ
that
ರೀತಿ
is-
ನಾವು ಕೋರ್ಟಿಗೆ ಹೇಳಿದ್ವಿ ನಿಮ್ಮ ಲಿಸ್ಟ್ ಕೊಡಪ್ಪ ಇಲ್ಲಿ ಬರ್ರಿ ನೀವು ಬಂದು ನಿಮ್ಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡ್ತೇವೆ ನಾವು ಬೇಗ ಬರ್ರಿ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತಾ ಅಲ್ಲೇನು ಈಗೋ ಟ್ರಿಪ್ ತಗೊಳ್ಳೋ ಪ್ರಶ್ನೆ ಏನ್ ಬರ್ತದೆ
I think
ಯಾರ್ಯಾರು ತಗೊಳ್ತೀರಿ ಅಂತ ಹೇಳ್ರಿ ನೋಡ್ರಿ 150 ಜನರಲ್ಲಿ 135 ಉಳ್ದಾರೆ ಅಷ್ಟು ಉಳ್ದಿರ್ಲಿಕ್ಕಿಲ್ಲ ಇದು ಯಾವಾಗ ತಯಾರಾಗಿದ್ ಲಿಸ್ಟ್ ಇದು
ಸರಿ ಮೊನ್ನೆ
I think, can I just suggest this, my lord?
ಕೊಡ್ರಿ
Let
ಅವ್ರಿಗೆ
them also, let them.
ನೀವೇನ್
let them-
ಕೋರ್ಟಿಗೆ ಹೇಳಿರಿ ಆ
We
ಪ್ರಕಾರ
can't,
ಕೊಡ್ಲಿ.
in fact, the review petition was disposed of on based on the
On that
undertaking.
basis.
I have no say whatsoever on this, because now it is an appeal. I can't withdraw this undertaking.
ನಿಮ್ ಕಂಪನಿಯಿಂದ ಯಾರು ಬಂದಾರ ಸ್ವಲ್ಪ ಮಾತಾಡಿ
ಯಾರು
ಅವ್ರ ಜೊತೆ.
ಬಂದಿರಲ್ಲ.
ಕರೀರಿ ಅವ್ರನ್ನ, ಯಾರು
ಬಂದಿರಲ್ಲ.
ಬಂದಿರಲ್ಲ.
Can I just request for then day after tomorrow, Wednesday?
Matter was
ಎಲ್ಲಿ
Heard.
ಕೊಡ್ತೀವಿ ಅವ್ರಿಗೆ.
at length,
Friday, no?
at length. Full stop. The no Friday. What you will look at?
14%.
All right, you argued, you said that nothing, you will not be heard much now. Yes, but ಅವ್ರದ್ದು employment ಕೊಡ್ಬೇಕು ಅಂತಂದ್ರೆ employment ಕೊಡ್ತಾರೆ. What is that? You want to put the spoke in the wheel? Yes, ಬರ್ಕೊಳ್ಳಿ. Both the sides having heard the matter at length, comma, fairly agreed to consider proposal of this court consistent with the company's assurance, consistent with Justice Anand Bhaira Reddy's review order dated
7/4.
so and so.
Order improvement.
So, for taking members of the registered trade union in employment. Full stop. This is really appreciable, although much time is spent in jurisprudential argument by now. Full stop. Call this matter to have the response of both the sides. Only with regard to the alleged assurances of the management to grant employment
As per the.
and in terms of the said order and the response of the workmen as well. Workmen stroke trade union as well. First, list on. Yeah, the list, but Shri, the council on record, Shri, appearing for the trade union, has shared a copy of the list of employees either.
Yes.
List of employees with material particulars. List of members of the trade union with material particulars. With Mr. Samit, the advocate on record, appearing for the.
ಒಂದೇ ಕಾಪಿ ಇದೆ.
ಇಲ್ಲೇ ಇದೆ.
ಕೊಡ್ತಾ ಇದೆ.
ಜಡ್ಜಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ಲಿ ಕೊಡ್ತೇನೆ?
ತಗೊಳ್ಳಿ, text ಮಾಡಿ.
ಈಗ ಇದೆ.
ತಗೊಳ್ಳಿ. ನಮ್ದೇ ಕೊಟ್ಟಿದ್ವಿ ವಾಪಸ್. Shared with them.
I will take the copy and make it 4-5 copies.
Aye, but. ಯಾತಕ್ಕೆ? ನೋಡ ಎಷ್ಟು ಜನ ಇದಾರ? ಎಷ್ಟು ಜನ ಎಂಪ್ಲಾಯಿ ಇದ್ದಾರೆ? ಬಿಡಿ, ಇಬ್ರಿಗೆ ಕೊಡ್ಸೋಣ, ಡೋಂಟ್ ವರಿ, ವೈ ಆರ್ಗ್ಯುಮೆಂಟ್? ನಿಮಗೆ ಕೊಡ್ಸೋಣ ಆಯ್ತಲ್ಲ, ಮತ್ತೇನು? Unless you want to put the spoke in the wheel, other things will not arise. ಎಷ್ಟು ಟೈಮ್ ಎಷ್ಟಾಯ್ತು ಕೊಟ್ಟದ್ದು? 2 ತಾಸು ಹೋಗ್ಬಿಡ್ತು. Now we are also responsible in wasting. After all, they want something to hold their bread and soul together.
Of course. No, and more than anything, there's an undertaking given already, which is why.
That's what.
My whole point was.
You come forward, with that. ಮುಗಿದೋಯ್ತು. And you cannot resile from that.
Cannot.
That is the stand which your client has taken.
Not in appeal purpose.
ಏನೇನೋ ಬಡವರು ಇರ್ತಾರೆ. ಮತ್ತೆ ವೆರಿ ಮೀನಿಂಗ್ ಆಫ್ ಅವರ್ ದಿ ವರ್ಡ್ socialist, it will be lost if we let down the workmen that way. ಏನ್ ಕಾನೂನು ಪ್ರಕಾರ ಇದೆ ಅದನ್ನ ಮಾಡೋಣ ಅಂತ ಅವ್ರೇನೋ ದೇ ಮೇ ನಾಟ್ ಬಿ ಜಸ್ಟಿಫೈಡ್ ಇನ್ ಸೀಕಿಂಗ್ ದಿಸ್ ದಟ್. ಇಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ದೇ ಆರ್ ಹಿಯರ್ ಫಾರ್ ಕಾಂಕ್ರೀಟ್ ಜಸ್ಟಿಸ್, ನಾಟ್ ಫಾರ್ ಬ್ಯೂಟಿಫುಲ್ ಆರ್ಡರ್ಸ್. ದೇ ವಿಲ್ ನೆವರ್ ರೀಡ್. ಈವನ್ ಲಾಯರ್ಸ್, ಜಡ್ಜಸ್ ಆಲ್ಸೋ ವಿಲ್ ನಾಟ್ ರೀಡ್ ಈಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ನೀವು ಆ ಪ್ರಕಾರ ಏನ್ ಹೇಳ್ತೀರಿ ಹೇಳಿ ಅವ್ರಿಗೆ.
WP 1144
simple.
ಅದನ್ನ ಪುಟ್ ಅಪ್ ಮಾಡ್ಬೋದಾ?
ಯಾವ್ದು?
that 33C2, that matter is pending before.
ನಾವ್ ಹೆಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ?
ಅಲ್ಲ, ಅದು ಇಲ್ಲಿ ತರಿಸ್ಬೋದಲ್ಲ?
ನೀವು ಆನರಬಲ್ CJ ಮೂವ್ ಮಾಡ್ರಿ. ವಿಲ್ ಬಿ ಹ್ಯಾಪಿ ಟು ಟೇಕ್ ದಟ್ ಆಲ್ಸೋ.
Submission could be recorded.
ಬಟ್ ಆ ಕ್ವಶನ್ ಬೇಡ ಈಗ ಇರಿ.
ಆಯ್ತು.
ಏನೋ ಒಂದು ಗುಡ್ ವಿಲ್ ಆಪರೇಟ್ ಆಗ್ತಾ ಇದೆ
ಆಯ್ತು.
ಅಲ್ವಾ? ಗುಡ್ ವಿಲ್ ಆಪರೇಟ್ ಆಗಂಗ್ ಮಾಡಿ.
ಆಯ್ತು.
ಎನಿವೆ ವಿ ಲರ್ನ್ ಲಾಟ್ ಆಫ್ ಲಾ ಫ್ರಮ್ ಸರ್ವೈವ್ ಅದಕ್ಕೆ. ಹಾ ಹಾ
ಅದು
we need not wait for you at all. ನೋಡೋಣ, ಲಾರ್ಜರ್ ಆಫ್ಟರ್ ಆಲ್ ಕಲೆಕ್ಟಿವ್ ಬಾರ್ಗೇನಿಂಗ್ ನಲ್ಲಿ ಕಲೆಕ್ಟಿವ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದಿ ವರ್ಕ್ಮೆನ್ ಈಸ್ ಇಂಪಾರ್ಟೆಂಟ್, ನಾಟ್ ಒನ್ ಆರ್ ಟು ದೇ ಮೇ ಬಿ ವಿಕ್ಟಿಮೈಸ್ಡ್. ವಾಟ್ ಟು ಡೂ, ದಟ್ ಹ್ಯಾಪನ್ಸ್. ಎಸ್. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್
Deposited 20 lakh. I've deposited 20 lakh.
ಏನಿದು ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ, ಕೇಸ್ ಸ್ವಲ್ಪ ಹೇಳಿ, ಫೌಂಡೇಶನಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ.
Phone number 3 is a company. The mobile tower is installed on the two schedule property.
On 21/11/2024, my lords made an order. Third respondent was a tenant of the premises. He
Correct.
wanted to withdraw the towers that were laid, but he admitted that he was in arrears of rent. My lords passed an equitable order that if you want to remove it, first deposit 20 lakhs.
ಕರೆಕ್ಟ್.
Now my learned friend says he has deposited.
ಮಾಡಿದಾರಂತೆ.
Please, my lords.
ಆ ಅಮೌಂಟ್ ಅವರಿಗೆ ರಿಲೀಸ್ ಮಾಡೋಣ. 32 lakhs. ಅಡ್ಮಿಟೆಡ್ ರೆಂಟ್ ಎಲ್ಲ ಕೊಡಿ.
Allala, that letter they admitted my lord, subject to my lord's condition. Aurge now on 11/10/2022 the agreement was terminated because on 6/9/2022 they locked the premises. ಆಮೇಲೆ ನಾವು 11/10/2022 ಗೆ terminate ಮಾಡಿದ್ವಿ. As on that date 11/10/2022 we have deposited the amount, number one. Number two, this 31 lakh was admitted.
ಈ ಕೇಸ್ ಎಷ್ಟನೇ ಯಾವಾಗಿನ ಸೂಟ್ ಇದು?
2015.
Huh?
2000, sorry.
Lords,
2010.
third respondent is not a party to the
I'm not a
suit.
party.
You were not a party?
I was not a party.
Between the
Rather.
tenants and respondents of owner, just tenant, not where the arrears of rent, taking advantage of these proceedings.
You also have the same grievance so far as the arrears of rent are concerned.
Yes.
You are all brothers, no?
Please.
In the partition suit. A suit is still pending.
No, suit is disposed of, my lords,
Disposed of.
against me, holding that it's a joint family property, whereas I am saying it's my individual property.
Okay.
Against that, I am before my lords. My suit for possession is dismissed,
Okay.
and their suit for partition is, their counterclaim for partition is decreed.
Okay. So that is how the appeal arises.
Please.
All right. ಈ ಅಮೌಂಟ್ ಈಗ ನಿಮ್ದು you oppose the removal of the
But subject to the deposit of 31 lakh.
ಆ ಡೆಪಾಸಿಟ್ ಅಮೌಂಟ್ ಇದೆಯಲ್ಲ, ಅದು ಇಲ್ಲಿ ಇರ್ಲಿ. It will be subject to outcome of the appeal.
Balance monies.
ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ಗೆ
1,23,183, yes, it was admitted. ಅವಾಗ as on the date of 7/10/2024 ಎಲ್ಲರೂ ಒಪ್ಕೊಂಡ್ರು ನಾವು ಮಾಡ್ಕೊಡ್ತೀವಿ, ಆಮೇಲೆ ನಮಗೆ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ ಬಿಡ್ಲಿಲ್ಲ. Then we have moved this before this honorable court.
ಅದೆಷ್ಟು ಅಮೌಂಟ್ ಎಕ್ಸ್ಟ್ರಾ ಎಷ್ಟಾಗ 12 ಲಕ್ಷ ಆಗ್ತದಾ?
31,23,183.
ಇನ್ನೊಂದು 11.5 ಲಕ್ಷ ಆಗ್ತದೆ.
ಎಕ್ಸ್ಕ್ಲೂಡಿಂಗ್ TDS ಅಲ್ಲ, TDS ಡಿಡಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ ರಿಮೈನಿಂಗ್. ಅದೇ SD ಅಮೌಂಟ್ ಮತ್ತೆ TDS ಅಮೌಂಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಿ ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ.
ಅದು ಟೋಟಲ್ ಲ್ಯಾಕ್ 19,45,000 odd.
ಅಲ್ಲ, this is what they have claimed.
They have said.
45,000.
The filing-
My lord, that
filing the-
direct us to deposit 20 lakh, which we have done. So on 7/10/2024, there was admitted of 31,23,183.
Professor,
My lords.
what we are just thinking is ಉಳಿದಂತ amount ಗೆ ಹೋಗ್ತದೆ. ಅದರಲ್ಲಿ ಮುಂದೆ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ವಾ? ಅಡ್ಮಿಟೆಡ್ ಪೊಸಿಷನ್ ಮೇಲೆ ಅಡ್ಮಿಟೆಡ್ ಪೊಸಿಷನ್ ಮೇಲೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಬೇಕಾಗ್ತದೆ?
20 ಲಕ್ಷ ಕೊಡ್ಬೇಕು, ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿ. ಯಾಕಂದ್ರೆ as of 11/10/2022 the agreement was terminated. ಈ ಲೆಟರ್ ಅಲ್ಲಿ ಅವ್ರು ಹಾಕಿರೋ ಲೆಟರ್ ಅಲ್ಲೂ ಬರ್ದಿದ್ದೀನಿ. The termination letter dated 11/10/2022. 18,45,000 and 20 lakh deposit ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ವಿ, which have done.
ಈ arrears of rent, it's the partition suit.
ಬಿಟ್ವೀನ್ ಅವ್ರ ನಡುವಿಂದ.
ಹೌದಾ?
ಅಲ್ಲ,
ಇದ್ರೊಳಗೆ ಅದ್ರೊಳಗೆ ಲೆಕ್ಕ ನಾವ್ಯಾಕೆ ಮಾಡ್ಕೊತ ಕೊಡ್ಬೇಕು? ಅದ್ರ ಮೇಲೆ ನೀವು ಕೊಟ್ಬಿನೂ ಕೊಟ್ಟಿಲ್ಲ, ನೀವು ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಇಶ್ಯೂನೂ ಇಲ್ಲ. ವೈ ವಿ ಶುಡ್ ಬ್ರೇಕ್ ಅವರ್ ಹೆಡ್?
ಅಲ್ಲ, ಅಲ್ಲಿ
ನನಗೆ ಪೆನಾಲ್ಟಿ ಬೀಳ್ತಾ ಇದೆ ನನ್ನ ಸರ್ವಿಸ್ ಕೊಡಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ. ಸೊ ಐ ಆಮ್ ಸಫರಿಂಗ್ ಪೆನಾಲ್ಟಿ.
ಪ್ರೊಫೆಸರ್,
My lord,
ಆ 20 ಲಕ್ಷ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಇಡ್ಲಿ,
Please,
ಇಂಟ್ರೆಸ್ಟ್ ಅಕ್ರೂಯಿಂಗ್ ಇದರಲ್ಲಿ,
Please.
when we take up the matter, this one, in the meanwhile, we will give liberty to proceed against him
Please.
for rest of the amount. ಅಲ್ಲಿ ನಿಮ್ಮ ಬ್ಯಾಟಲ್ ಲೈನ್ಸ್ ಡ್ರಾ ಮಾಡ್ರಿ, ಕೇಸ್ ಮುಗಿಸೋಡ್ರಿ.
please,
ಈ ಅಮೌಂಟ್ ಏನಿದೆ ಅಲ್ಲ, to that extent we will give him discharge
Please.
and we permit him to remove the
Tower.
tower also. All right, do you agree with this? All right, all of you agree with this? ಬರ್ಕೊಳ್ಳಿ.
Second letter has been addressed by him. We comply with the set conditions. ಕೆಲವು works ಆಗ್ಬೇಕಾಗಿದೆ. Civil works
You go, you
civil
fight-
work
you
ಮಾಡ್ಕೊಳ್ಳಿ.
fight a litigation separately in respect of that.
Whatever the terms and conditions which we have accepted in the letter, the
Ah.
second letter, we will do it.
You will do
Yes,
that.
yes.
All right, ಬರ್ಕೊಳ್ಳಿ. This appeal calls in question a partition decree. First of all, ನೀವು ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ರಾ?
ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ ನಮ್ಮಲ್ಲಿ
The occupant of the subject property,
only second floor.
Eh?
Only second floor terrace.
that is the terrace of the second floor, correct? Second floor, on which the tower is mounted, and mobile tower. Mobile tower is mounted. Complained before us that he was not being permitted to remove the tower. Of course, without causing any damage to the structure in question. First, at this stage, the parties to the decree stroke appeal raised a contention as to the tenant being in arrears, and if he is permitted to remove the tower, comma, there would be nothing to enforce his liability. According to them, this being around 32 lakh rupees, 32 lakh. First, at that stage, we proposed to the tenant to deposit in the registry of this court a sum of rupees 20 lakh, which he has done. First, therefore, counsel for the tenant presses us to permit removal of the said tower. First, the counsel appearing for the partition decree oppose this contending that another sum of rupees 12 lakh, about 12 lakh is still due, and unless that is settled, comma, permission as sought for may not be granted. First. Next paragraph. Having heard the learned counsel for the parties and the counsel appearing for the tenant as well, comma, we deem it proper to make the following order, which is largely with which largely all they are unanimously agreeable. First, number one, the amount in deposit shall continue to be parked in an interest earning scheme of a nationalized bank on a normative basis, and the said amount along with accrual would inure to the benefit of party who would emerge victorious in the appeal, or as may be ordered in the appeal in that regard. Number two, the tenant shall be permitted to remove the subject tower without causing any damage to the structure in question, within what period you will remove that?
30 days. Within 30.
Within an outer limit of 30 days. 30 days. First off, whatever damage inevitably happens because of in the removal process, comma, shall be restored before the said tower is removed from the premises as such, and till that is done, it is open to the parties to the decree to detain it, to coerce repair. First, next paragraph. The parties are at liberty to litigate over rest of the amount payable by the tenant, and the cause of action for that would be this order. Shall be reckoned from day of this order. This order. First off, all contentions in the contemplated proceedings are kept open. Kept open. ನೀವೇನ್ರ ಹೇಳೋದಿದ್ಯಾ? ಏನೋ ಹೇಳಿದ್ರು ನಿಮ್ ಕ್ಲೈಂಟ್.
On submission.
Apart from 12 lakhs, after 1 year, 2023 calculate ಮಾಡುವ.
ಅಲ್ಲ ನಾನು 11/10/2022 agreement
ಅಲ್ಲೇ 12 lakh or otherwise or any other sum. Okay.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ 3 ಜನ ಒಪ್ಪಿದ್ರೆ ಈಗ ಇನ್ನು 11,23,183 ರೂಪಾಯಿ ಏನ್ TDS ಇದೆ ಅದನ್ನ TDS ಡಿಡಕ್ಟ್ ಮಾಡಿ ಪ್ಲಸ್ 1 ಲಕ್ಷ ಸೆಕ್ಯೂರಿಟಿ.
ಈಗ TDS ಡಿಡಕ್ಟ್ ಆಗೇ ಮಾಡಿದ್ದನು?
ಇಲ್ಲ ನಾನು 20 ಲಕ್ಷ ಹಂಗೆ ಡಿಡಕ್ಟ್ ಮಾಡಿ.
ಅದನ್ನ ಇಲ್ಲಿ ಇಟ್ಬಿಟ್ಟೇವಲ್ಲ ನಾವು, ಹಂಗಾಗಿ ಅದು ಕೊಟ್ಟಂಗ ಆಗಲ್ಲ ಬಿಡಿ.
ಒಪ್ಪಿದ್ರೆ 3 ಜನ 31 ಲಕ್ಷ ಮಿಕ್ಕಿದ್ರೆ
ಏನ್ರಿ
ಡಿಡಕ್ಟ್ ಮಾಡಿ ನಾವು
ನೀವಿಬ್ರು ಒಪ್ಪಿರಿ.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ.
ಡೆಪಾಸಿಟ್ ಕೊಟ್ಟು
ಬೇಡ ಕೋರ್ಟ್ಗೆ ಡೆಪಾಸಿಟ್.
ಅದು ಯಾರು ಗೆಲ್ತಾರ ಗೊತ್ತಿಲ್ಲಲ್ಲ.
ಆಯ್ತು
ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಆಗ
ಆಯ್ತು.
ಅದು ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡಿ?
ಅದಕ್ಕೊಂದು 40 ಡೇಸ್ ಟೈಮ್ ಕೊಟ್ಟು ನಾನು ಡೆಪಾಸಿಟ್.
ಆ 30 ಡೇಸ್ನಾಗ ಆಗ್ಬೇಕು. ಅದಕ್ಕೆ 40 ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಇಲ್ಲಿ ತೊಗೊಂಡು ಹೋದ್ರೆ 30 ಡೇಸ್ನಾಗ ಮುಂದೆ ಅವ್ರು ಹೆಂಗ್ ಅನ್ಕೊಂಡು
ಅವ್ರಿಗೆ 40 ಡೇಸ್ ಬೇಕು ಅಂತ ಇದೆ.
ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. When we finished the dictation of this part of the order, comma, the counsel for the tenant on the instruction of his client standing behind Srimati so and so offered and the counsel representing the parties to the decree in challenge on the instructions of their client also accepted the offer that the tenant shall pay another sum of rupees
11,23,183 after deducting TDS.
ಬರ್ಕೋಬೇಕಲ್ಲ. 11,23,183 after deducting TDS for what amount?
31 lakhs deduct.
For the entire amount.
Security deposit already with
We have forfeited, then security deposit ಯಾರು ತೆಗಿತಾರೆ? That amount also will go to them only. Minus security deposit. Minus security deposit. ಅದಕ್ಕೆ half rupees 1 lakh.
Minus
1 lakh. First off, this payment should be made within a period of 30 days. Within a period, within the period, this payment shall be made before taking the dismantled tower out of the premises of the suit property.
please.
All right. No.
Balance money, if any, we are at liberty to file a separate suit, my lords.
No.
My lords.
This is complete package. ಹೌದು, ಅದ್ರ ಮತ್ತೆ ಇನ್ನೊಂದು ಸೂಟು ಇನ್ನೊಂದು ಕೇಸ್ ಬೇರೆ ಅದನ್ನ ಮಾಡ್ಕತ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
ಇನ್ನು ಒಂದು ವರ್ಷ
ಕೊಟ್ಟಿದ್ದಾರೆ.
rent ಹೋಗುತ್ತೆ.
That would put all causes of action arguably availing against the tenant to a decent burial. Okay.
Dismantle process start ಮಾಡ್ತೀವಿ.
ಹಾ ಮಾಡಿ ಅದನ್ನ ಒಯ್ಯಂಗಿಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ಟು ಆಮೇಲೆ ಒಯ್ಬೇಕು ಹೊರಗೆ. ಡಿಸ್ಮ್ಯಾಂಟ್ಲಿಂಗ್ ಮಾಡಿ
ಅದಾಗ
ಅಲ್ಲ ಒಂದು ಸ್ವಲ್ಪ ಲಿಂಗ್ವಿಸ್ಟಿಕಲಿ ಸ್ವಲ್ಪ ಇಟ್ ಮೇ ಅಂಡರ್ಗೋ ಲಿಟಲ್ ಚೇಂಜ್ ಬಟ್ ಜಸ್ಟ್ ರಿಮೈನ್ಸ್ ದಿಸ್.
Please.
ಓಕೆ
Great.
ಅಲ್ಲಿ ಆ ಅಮೌಂಟ್ ಅನ್ನು ಇಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ನೀವು.
ಆಯ್ತು. ಇಲ್ಲೇ-
ನೋಡಿ.
ಇಲ್ಲೇ-
The said amount shall be deposited again in the registry.
And that will also be the,
ಅಲ್ಲಿ TDS GDS ಮಾಡೋ ಬದ್ಲಿ ಇದನ್ನ ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಮುಂದೆ ಅದನ್ನೆಲ್ಲ ಅವ್ರು ವರ್ಕೌಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ TDS ನಾವು
ನಿಮಗೆ ಬರೋ ಲಯಬಲ್ ಬರ್ತದೆ ಅಂತ. ಓಕೆ ಆಲ್ ರೈಟ್.
that may also be kept in a interest bearing security.
Same after the said amount to be deposited shall be again parked in a usual way in an interest earning scheme. Okay. Disposed of. Okay. Next.
Yes, ma'am.
ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ಳೋಣ, ಒಂದು 10 ನಿಮಿಷ ಇದೆ. ಇರಿ, ಇದು ಯಾವ ಡೇಟ್, ಯಾವಾಗಿಂದ ಇದು?
This is the matter of 2014, sir.
14. All right, no problem.
2022.
Huh?
2023 is, I
22
filed
was
the,
filed.
Dispute of matter.
Yes.
What is that? Do you know?
She has filed an application
Ah.
for correction of the order.
Correction of the order.
Yes.
What is to be corrected, madam?
Yes.
this is the contempt proceedings to be initiated against the accused husband, sir. The final order was passed on the 30th October by the bench. And the final order, there is a line which states,
What was the settlement? There was settlement.
Yes, I'll come to that settlement. ma'am.
settlement is in Annexure A,
My
page
lord,
number 9, sir.
may I submit? Let this be decided, let the application be decided first.
We are deciding it now.
Yes. Yes, ma'am.
Yes. We want to recall that order.
Yes. It is there, my lord. It's there.
Okay, 30th October order passed by the bench. And
That the second order where we had rejected that application.
Yes.
But we grossly erred in reading the order at page 12, the matrimonial court order. In matrimonial proceedings, the courts have held, they have to be construed, the orders made in matrimonial proceedings have to be construed a bit in a different way than the orders made elsewhere in other litigations.
Yes.
Now, do you have that order dated 2/9/2014? Both the parties in view of this agreement have filed a memo jointly to dismiss the petition as not pressed. Since the petitioner agrees that unconditionally withdrawn, the above petitioner is at liberty to file a fresh petition on some grounds, so and so. This itself constitutes the substratum of the order. No settlement possible?
Not
Where?
at this stage, my lord. From 2008, I've been suffering. Till 2024, even today, there are several cases pending before the family court, undecided, and before the criminal court.
What was the settlement?
Lordship, kindly refer page number 9. It is a joint affidavit that we filed between the husband and myself. And there are voluntary submissions that the husband has made in the joint affidavit, which has been willfully breached for the past 10 years. And he has
What was
extended
the-
on his own.
ಹೇಳಿ ಆಗ್ಲೇ. You know that. Why do you want to read?
Ready and willing to stay together.
Yeah. I'll
This
read
was
out
the
my
agreement.
lordship. Lordship, it is, we
Let
are
her finish,
ready and
madam.
willing. This is the accused husband's voluntary submissions, which says we are ready and willing living together without any conditions to each other, except the husband has agreed to set up a matrimonial home at Bengaluru for his family and will be shuttling to Bengaluru on weekends and other holidays as long as required, and he will continue his present job at Madurai. In view of the facts, the above case may be disposed of in the ends of justice. This is the joint affidavit that we have filed in the family court, based on which the conjugal rights petition and the divorce petition back then in 2914 was disposed of. And then since then, he set up the matrimonial home. He complied for 3 months, and on 21/12/2014, he has willfully withdrawn from the settlement. Until now, we do not know what is the reason. and he has willfully breached and he is extended on his own.
Your case is, we have heard you. Anything more to submit?
Lordship, again, this is my conjugal rights petition in which the joint affidavit has been filed. And the decree was drawn on the 5th of August 2024. And Lordship, there is also from the respondent side, the writ petition order 6210 of 2024. Kindly refer to that. Page number 10.
This requires a little deeper consideration. We'll just see, post this matter immediately after, after vacation.
Lordship, they have deferred the execution petition order in the family court,
we are-
stating that this court's order has to be
That's
published.
true, that's true. But in another 20 days, nothing is going to happen. We are in urgency. This matter, already you have suffered one dismissal of the recall application. Still, we want to be lenient because this is a matrimonial dispute. Therefore, you have to give us some time to reflect on that. Ah. Call immediately after vacation. Next. ಏನಿದೆ?
Matter relates to selection and appointment to the post of assistant engineer.
Ah.
My lord, the notification was issued on 29/1/2016. My lord,
What the tribunal say?
Tribunal says, my lord, the date of acquiring the degree would be the date on which the mass card has been issued.
Mass card has been issued.
That is the date on which.
Decree. Degree was when convocation happens. When or the result is declared. When the result was
My lord,
announced.
the exams were held on in September 2001, my lord.
1 second. Exams
Were held in September 2001.
2000.
One.
Ah.
My lord, the notification specifically says, my lord, that the qualification one should have acquired the qualification as on
Notification is dated
29/1/2016. It says that, my lord, the one should have acquired the degree prior to 21/11/2001.
prior to
21/11/2001.
21/1/01.
My lord, the degree certificate was issued to me on 10/7/2002, specifically stating that I have completed, passed the exam in September 2001.
Degree certificate dated
10/7/2002.
that how it reads, read that.
Blood, a bachelor's of degree, Mahesh Prabhu K has been duly admitted to the degree of Bachelor of Engineering in recognition of fulfillment of the requirement for the said degree as indicated below. Year of examination, September 2001, subject civil engineering.
Year of examination.
Yes, my lord, 2001.
Yes, you get the degree only when the certificate is issued.
Now, this certificate is issued on 10/7/2002.
That is much after 19/21/2001.
Yes, on an information sought by the tribunal, my lord, from the Bangalore University, the university has specifically stated the reason for delay in issuing the degree marks card and the certificate is because they could not print the
Result ಯಾವಾಗಾಯ್ತು?
result is not forthcoming from the records, my lord.
ಹೆಂಗೆ?
My lord, the marks card was issued on 10/7.
ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನ 10 ವರ್ಷ ಬಿಟ್ಟು ತೋರಿಸ್ತೇನೆ ನಾನು. ನಿಮ್ ರಿಸಲ್ಟ್ ಯಾವಾಗಾಯ್ತು? When the result was announced, past failed result was announced. That is the date ಅಂತ hold ಮಾಡಿ. ಯಾವ್ದದು? ಅಂಜಯ್ ಬನ್ಸಾಲ್ ವರ್ಸಸ್ Bangalore University. Which is that? There are two judgments on this.
Yes, my lord, under identical circumstances, placing reliance on the university's statement, my lord. The others have already been,
We want to know when the result was announced.
that I'll secure instructions, my lord. The date on which the results were announced.
Counsel for the petitioner to secure the information as to when the results of the subject examination held on 1/9/2001 were announced, regardless of when the marks card has been issued.
Please.
since this bears, that will be the clinching point. Please, that will be the clinching point of the case. Okay. Next.
For the petitioner, I may be permitted to file the second segment. Weeks time.
Second set to be filed within 1 week, failing which the petition stands rejected.
Please.
Different in this. It's an application is filed for amendment of the plaint. For this, not this. The suit is filed.
After case madam.
The short point is that even BDA can also consider, the agreement was entered into by the BDA with us for purchase of the land. They have taken about 50% of the land, they have utilized it. It is the agreement with possession. And we filed a suit. Ultimately, this honorable court has permitted us to file a comprehensive suit before the trial court. We filed a comprehensive suit. But there is a mistake. What happened was in Schedule D was, they have constructed the building. Schedule C, they have not constructed the building. That is about 18 guntas of land. And what happened was, while filing the suit, they sought possession of Schedule D instead of Schedule C. That is, they know, I filed an application directing them to hand over the Schedule C property. Admittedly, they have not paid compensation. The agreement to sale has not been enforced and suit has not been filed. So far, they have not said we are coming with this thing, but we have been permitted to put up the compound and safeguard the property also. Now,
but
whatever the property they have already taken.
But new property will be introduced if we agree.
38 guntas of the land, we have agreed to sell the property in their favor on certain consideration. They have paid some part of the consideration. Remaining, they have not paid. They have not filed the suit for specific performance. And we have handed over, I am not disputing that some portion of the property. They have put up the construction. And ultimately, this honorable court permitted us to file a suit, a comprehensive suit. We filed a comprehensive suit, but while describing schedule, instead of Schedule C, we made as a Schedule D. Schedule D, they have already constructed. That is what we want to trial judge.
Question of getting that property back will not arise at all.
D will not, because they have already constructed. And another thing is, the learned judge has granted an injunction not to alienate the property. They cannot do anything. So therefore, some via media may kindly be considered, because 50% of the amount they have paid, let them take 50% of the property and leave this 50% to us. Or else they have to pay the compensation according to the present market value.
Objections, Hakira.
Objection, forfeit. To file an objection.
File objection. Very important, Alva.
The objection, to file an objection has been forfeited.
Forfeited, but it will be a threat to the litigant too. Wide order dated so and so time was granted to the respondents to file objections to the IA seeking leave to amend the prior column in a time-bound way. In the default, that right to file one would stand. Why our order dated 5/11/2024, we had said as under. Next paragraph. Despite threat, comma, no objections are filed. And therefore, learned senior advocate appearing for the appellant submits that the application has to be heard on merits without the objections only. First. However, we are of the considered view, next view in the fact matrix of the case, that one more opportunity needs to be granted to the respondents to file the objections within 2 weeks, okay? ಏನ್ ರೆಡಿ ಅಂದ್ರೆ ಏನರ್ಥ ಫೈಲ್ ಮಾಡ್ದಂಗೆ ಇಂಥ ಆರ್ಡರ್ ಇದ್ರೂ ಫೈಲ್ ಮಾಡಲ್ಲ ನೀವು. ಆಮೇಲೆ ಒಂದು ವಾಟ್ ಈಸ್ ರಾಂಗ್ ವಿತ್ ದೆಮ್? ಡಿ ಶೆಡ್ಯೂಲ್ ಡಿ ಈಸ್ ದೇ ಹ್ಯಾವ್ ಪುಟ್ ಅಪ್ ದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂಡ್ ಬಿಲ್ಡಿಂಗ್ ಇದೆ ಅಲ್ಲಿ. ಇದೆಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿ ಹೇಳ್ಬೇಕು. ಬೈಂದ ಹೇಳಿದ್ರೆ ಹೆಂಗಾಗತ್ತೆ?
ನಮ್ಗೇನಿಲ್ಲ ನಮ್ ಪ್ರಪೋರ್ಷನೇಟ್ ಪ್ರಾಪರ್ಟಿ
ಸಿ
ಕೊಟ್ಟರು
ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ ನಮ್ ಪ್ರಪೋರ್ಷನೇಟ್ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟರು ಸಾಕು ನಮ್ಗೆ ವಿ ಆರ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಇದು ವಿ ಡೋಂಟ್ ವಾಂಟ್ ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ.
Call in the second week of January 2025. ನಾವ್ ಹಿಂಗ ಹೆದರ್ಸ್ದಾಗೂ ಹಾಕಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋಣ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಆಮೇಲೆ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ದಾಗ ಇಂತ ಡಿಸೈಡ್ ಮಾಡೋದು ಹೆಂಗೆ? ಎಷ್ಟಿದೆ ನೀನು petitioners, my lord. Yes.
But the urgency is this. Now they went to Supreme Court and there is some observation. Now my protection is lifted and they are precipitating the matter. Of course, passover I have no problem, but the urgency is that
ಪಾಸೋವರ್ ಹೆಂಗೆ ನಮ್ದು ಫಸ್ಟ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ಮಧ್ಯಾಹ್ನ.
precipitating the matter. I will make submissions. Let them reply.
Apex court order.
No, what happened is this, my lord. I'm sorry.
All right. Call this matter tomorrow at the request of counsel for respondents. Yes. Next.
Age is appearing, my lord.
ಯಾಕೆ ಅಡ್ಮಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ? ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದೆ ಹಂಗೆಲ್ಲ ಬರೆಯೋದ್ರಿಂದ. ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಂತ ಹೇಳ್ಬೇಕು. ನಮ್ಮ ರೂಲ್ಸ್ ನಲ್ಲಿ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್, ಅಡ್ಮಿಷನ್ ಇಸ್ ಡಿಫರೆಂಟ್, ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಈಗಾಗಲೇ. ಅಡ್ಮಿಷನ್
This is already ordered, my lord. Notice ಆಗಿದೆ.
ನೋಟಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರು ಇದೆ.
Yes, ma'am.
ಎಂಟ್ರಿ ಮಾಡರ್ ಟು
Please, obliged.
post for preliminary hearing B group. Okay.
Lord, I appear for petitioner, my lord. Lord, I beg your pardon. It may be taken tomorrow, my lord.
Tomorrow.
Learned AG has to appear in
Tomorrow.
this. Obliged.
Next. Tomorrow ನಾಳೆ ಬರಲಿ. 2:30. 371J we have. 2:30 ಇದನ್ನ ಮಾಡ್ಕೊಂಡು ಅದನ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಟುಮಾರೋ.
Obliged.
ಮತ್ ಟೈಮ್ ಕೇಳಬಾರ್ದು, ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಅದು ಅದರಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಎಸ್ ನಾಗರಾಜಪ್ಪ. ಎಸ್ ಮೂರು ಏನಿದು?
Amicus curiae, my lord, senior advocates.
That matter. LIC suicide happened, na? Okay. Mr. Learned Amicus Curie, kindly tell us, sir. ಅಲ್ಲೇ ಮೈಕ್ ಅನ್ನು ಹತ್ತಿರಿಡಿ ಅವರಿಗೆ.
My apologies. I disturbed the.
No, absolutely not. ಅದು ಗೊತ್ತಾಗಲ್ಲ ಅದು. Okay.
ನನಗೂ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
It happens generally when lawyers stand up, the medical science says a little BP goes up because of anxieties. Not for you. Certainly not for you. Yes, sir.
Validity of Rule 38 was called in question in the earlier proceeding. And at page 151 of the writ petition, it is held that in view of the consideration made above, we are of the view that the applicant has made out a case to grant the relief sought to declare that Rule 38 is unconstitutional. This has become final. When the matter was, the tribunal.
Where is the order striking down that rule?
That is the.
That should be inferred from this text.
Yes, my lord. After discussion, conclusion is there. Kindly The discussion commences from para 16. Page
We'll,
144.
We feel ಸ್ವಲ್ಪ ಡೀಪರ್ ಕನ್ಸಿಡರೇಷನ್
ಹೌದು, ಹೌದು.
ಅವಸರ
Milord,
ಬರೆಯೋದಲ್ಲ.
The second submission I make is parents patria. The duty of the government in taking care of this government. The third thing is, it's not canvas so far in rules, sections 3 and 4 of the Competition Act. Monopoly is established by the government by the sole insurer in the state. Therefore, the Competition Act applies. Section 3 of the Act and Section 4 would hold that agreement of the present type, saying that within 1 year, if he dies or commits suicide, upon the law, or 1 year waiting period, both the classes are unconstitutional. This has not been considered void and healthy.
Section itself is there.
Yes. The agreement is void and
Agreement is wider.
Agreement.
ಇದು ಅಗ್ರಿಮೆಂಟ್ ಆಗಲ್ಲ, ರೂಲ್ ಆಗತ್ತೆ.
policy. Rule 38 policy makes out.
Policy is pursuant to agreement.
Yes, sir. That's what.
ಹಾಗಾಗಿ
That's why I started with that. The earlier round of litigation, the rule was held to be void. That has become final. And now there only were 3 submissions. Parents patria. Government cannot take this stand.
Government cannot take it this time.
This stand to say that I deny my subjects the benefit of this. Premium is collected. Rule 15 says of the rules, the moment premium is collected, risk commences.
No, but that is made in the exercise of parent patria doctrine only. Because they want to see nobody commits suicide.
Is that the public policy?
That's the public policy. Consistent, at least within 1 year of buying the policy, they should not commit suicide. If they, that's the policy. Because every Atma is treated as sacred by our system. No Atma should commit Atmahatya ಆಗ್ಬಾರ್ದು ಅಂತ.
ಆತ್ಮಹತ್ಯ
ಹೌದು.
ಅಲ್ಲ, ನಮ್ಮ ಧರ್ಮದಲ್ಲಿ
ಹಂಗಿದೆ.
ಅಲ್ಲ, ತಮಗೆ
ಆತ್ಮಹತ್ಯ ಮಹಾಪಾಪಂ.
ಹೌದು. The only thing is it's not available to be punished.
ಅಷ್ಟೇ. Because ಹಂಗಾಗಿ ಪಾಪ ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ punishment is in the other world, not here. It's what History of Dharma Shastras by P.V. Kane says in one, I think, volume 6. He says that for Papa in our
No, for the benefit to the learned law officer, I'm mentioning it so that he should know what I have. I'm not arguing either.
Of course, they are already saying, therefore we appointed.
Yes, that I'm submitting to the Honorable Court that
But requires that Competition Act. This we did not have any idea at all. Therefore, we let us examine that after vacation morning. ಅವಸರ ಮಾಡೋದು ಬೇಡ. Next. But you have given a new twist to the case by bringing that Competition Act now.
ಇಲ್ಲ, ಇದು ಅದು ನನ್ನ
That was not examined, my lord, earlier.
That's what.
That's a learned senior.
In all scriptures, even in Islamic scriptures, the Atmahatya is considered to be a very big sin.
It's a moral offense.
But always during my college days, when I read Robert Clive having fought the War of Plassey with Sirajud-Dowla and won, he founded British Empire in India in 1757, but went back to UK and committed suicide. I was really, it was a student, of course, even now.
Anyway, speaking for myself, my days are getting over soon. I was to know how this memory is cultivated. ನನಗೆ ಸಾಧ್ಯ ಇಲ್ಲ ಇದು.
I do not know.
Robert Clive.
I can't lay claim to any greatness by that because I inherited it from my some ancestors.
For the benefit of the bar, the next generation, we wish to know the secret. Is it an exercise?
But if I say that you or at least others, some section may not be happy. The memory, the Bhagavad Gita says, Smrti Bhramshat Buddhi Nasho buddhinashat pranashyati. If memory power goes down, the dhi shakti, the intellectual might, diminishes. If that happens, the fall begins ಅಂತ ಹೇಳ್ತಾನೆ.
Alzheimer, ಅದೇ ಒಂದು ಕಾರಣ.
ಭಗವದ್ಗೀತೆಯಲ್ಲಿ ಇದೆ ಇದು. ಇದು ಭಗವಂತ ಹೇಳುವಂಥದ್ದು. And he has also given hints as to how memory power should be retained. ಇಮಿಡಿಯೇಟ್ಲಿ ಒಂದು 15-20 ಸೆಕೆಂಡ್ ನಲ್ಲಿ ಹೇಳಬೇಕು ಅಂದ್ರೆ ಅದಕ್ಕೆ ಗಾಯತ್ರಿ ಜಪ ಮಾಡಬೇಕು, ಪ್ರಾಣಾಯಾಮ ಮಾಡಬೇಕು. ನೀವು ಅದನ್ನೆಲ್ಲ ದ್ವೇಷ ಮಾಡ್ತೀರಿ, ನಿಮ್ಗೆ ಹೆಂಗ್ ಸಾಧ್ಯ ಅದು? ಅದನ್ನೆಲ್ಲ ದ್ವೇಷ ಮಾಡಿದ್ರೆ ಶಂಕರ್ ಅವರು ಹೆಂಗೆ ಸಾಧ್ಯ ಆಗ್ತದೆ? ಅದಕ್ಕೆಲ್ಲ ಗಾಯತ್ರಿ ಜಪ ಮಾಡಬೇಕು, ಮೆಡಿಟೇಷನ್ ಮಾಡಬೇಕು, ದೀರ್ಘವಾದ ಉಸಿರಾಟ ಮಾಡಬೇಕು, ಭಗವಂತ ನೆನೆಸ್ತಾ ಇರಬೇಕು, ನಂತರ ಹಸಿ ಕುಂಬಳಕಾಯಿದ ರಸವನ್ನ ಕುಡಿಬೇಕು, ಪ್ರಾಣಾಯಾಮವನ್ನು ಮಾಡಬೇಕು, ಅದಕ್ಕೆ ಸೂರ್ಯ ನಮಸ್ಕಾರ, ಚಂದ್ರ ನಮಸ್ಕಾರ, ನಕ್ಷತ್ರ ನಮಸ್ಕಾರ, ಯೋಗಾಸನ ಇವುಗಳನ್ನು ಮಾಡಬೇಕು. ಇದು ನೀವೆಲ್ಲ ಇದನ್ನ ಅಪೋಸ್ ಮಾಡ್ತೀರಿ ನೀವು, ಮತ್ತೆ ನಿಮ್ಗೆ ಹೆಂಗೆ ಮೆಮೊರಿ ಬರ್ತದೆ ಶಂಕರ್ ಅವರಿಗೆ? ಎನಿವೆ ಇದು ಯಾವುದು ಮಾಡ್ದಂಗೆ ಜರ್ಮಿ ಬೆಂಥಮಿಗೆ ಗ್ರೇಟ್ ಮೆಮೊರಿ ಇತ್ತು. ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. He never did all these things, but he said to Raja Ram Mohan Rai when he went to England to argue a Maharaja's matter, there Bentham took him for dinner, saying that I'm a pure vegetarian. I know that you will not eat non-veg, but come, I will give you, but provided you give your intellect to me. This is what Jeremy Bentham said to Raja Ram Mohan Rai. Imagine that one. This one, but my memory is not that great. I know that. Anyway, you are praising me. Any praise, even when it is not true, makes man happy. Maybe. I do not know. Yes. But I only request you. I only request you through others also, through you and you, that you should not despise the great, the scholarly work of our Rishi Munis and other things. They are simply scholarly on mathematics, science, astrology, philosophy, anything. I'll see what greats have said. Arnold Toynbee, Will Durant, William, what they have said about Max Muller, what they have said about this. Only I said this to you and not to anybody else. Yes. After vacation, I couldn't. Mr. Shankar, can you have this after vacation? Okay.
This is suspension matter, my lord. AG has to appear. He is on legs in court hall 1.
Suspension matter ಬರಬೇಕಿತ್ತು. ಅದು immediately after vacation.
ಇಲ್ಲ, day after tomorrow. He wants it on day after tomorrow.
ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಇಷ್ಟು ವರ್ಷ ಆಗಿ ಅದೇ 500 ಅಲ್ಲ 300 ಕೋಟಿ. I just calculated, it works out to 1300 odd crores.
Yes, sir.
After,
day after.
at least from part that after vacation. Yes.
Please. But interim order may be extended.
Interim order ಇದೆಯಾ?
Yes.
ಹಂಗಾರೆ day after tomorrow ಮಾಡಿ.
Obliged.
All right. Next.
After hearing all the parties, interim order is granted.
Okay.
After vacation, if
It is
I
what
request my lord,
After vacation. Interim order to continue. Okay. But here ಮಾಡಿದ್ದೇವೆ ಮತ್ತು they may mistake us.
The matter has to be heard, my lord.
My lordship, this is a matter wherein he's given an option whether he would want to take
Heard your
welcome or
lordships,
not.
my lord. Any day, your lordship, may kindly.
ಏನು
Hear the matter on
ಹೇಳಿ,
that.
ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬಿಡಿ, ಮುಗಿದೈತೆ, ಬೇರೆ ಏನಿಲ್ಲ.
So we take some time, my lord. 5-10 minutes.
You want time?
Because, my lord, the respondents, my lord, they are working. There is no problem.
Respondents?
They are working in the present place. But I am the person who has, my lord, without.
Deprived. You are working now,
Continue.
but don't file unnecessary, we'll give you time. Don't file a criminal
Hey,
case.
no,
and
no,
don't
my lord, that's
precipitate
not-
the criminal
One
case.
Mr. Swami has filed, my lord. That's
Not
the reason
you.
I want. I am not from my side.
Filed
My lord,
through
I-
him, the complaint contains his name and what is transpired.
What
One-
control he will have over Swami.
Your lordship, I shall.
Swami.
Anyway, call this matter
Your lordship.
immediately after vacation.
Real.
In the meanwhile, the petitioner shall not do anything that would put the private respondents to any affliction in any way. Okay. Yeah, this takes care of your client also.
Please.
Okay.
Ob-
Further hearing.
Obliged.
All right.
I appear for the.
Today, not possible. We have, you know that we have 2 meetings and we have another bench also. Some date, sir, you can choose whichever date you
We
want.
shall leave it to your lordship, my lord.
Huh?
That means only after the vacation
After
probably.
the vacation.
It is possible, lordship, kindly have it on Monday, next Monday. day after.
Difficult. ಕೃಷ್ಣಮೂರ್ತಿ ಡಿಫಿಕಲ್ಟ್ ಇದೆ. ಯಾಕಂದ್ರೆ ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡಿವಿ ಇಬ್ರು.
ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳುತ್ತೆ ಇದು, ಬಟ್ ಇದು
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ವೈಂಡಿಂಗ್ ಅಪ್
ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮಾಡಿ.
Very well.
So photo adjourned to the third week of January 2025. Okay, for want of time. Okay. Entry ಮಾಡ್ರಿ ಏನ್ರ ಇದೇನು?
ಏನು ಇಲ್ಲ, ನೋ ಎಂಟ್ರಿ.
The lordships kindly, my lord.
Sir, ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ?
After vacation, released from party.
It is a prison.
ಸರ್ ನಮ್ದು
ನಾ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋಣ ಅನ್ಕೊಂಡೆ.
ಸರ್ 15
ಇದೆಯಾ?
ಸರ್ ಮಧ್ಯಾಹ್ನ ಸರ್ ಮಧ್ಯಾಹ್ನ ಒಂದು ಡೇಟ್ ನಮ್ಮ 15 ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಸರ್. ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ
ಸರ್
ಸರ್.
ಇದೊಂದು ಕಂಪಾಷಣ
ಯಾವ್ದೊಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್ ಬರೋ.
ಸರ್
15 ಸರ್ ಈ ತಿಂಗಳ ಆಗಲ್ವಾ? 17, 18, 19 ಯಾವ್ದೊಂದು ಡೇಟು ಸರ್? 17, 18, 19 ಯಾವ್ದಾಗಲ್ವಾ?
ಸರ್
8 ಹಾಕೊಳ್ಳಿ ಸರ್. ಸರ್ 8 ಸರ್ 8 ಸರ್.
ಸರ್ 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 ಕೇಳಿ 17 ಸರ್ ಅದು ಆಕ್ಚುಲಿ ಸರ್ ಕಂಪಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಪ್ಲೀಸ್ ಒಂದು ಪ್ಲೀಸ್ ಸರ್ ರಿಕ್ವೆಸ್ಟ್ ಇದೆ. ಅಲ್ಲ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸರ್, ಅದು ಕಂಪಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. ಸರ್ ಒಂದು ಡೇಟ್
Serial number 21.
ಸೊ ಗೊತ್ತಿದ್ರೆ ನಾನು ಇಲ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು.
ಸರ್ ನಾನೇ ಸರ್ 15 8 16 ಫೋಟೋ ಸರ್ ಅಪೇರ್ ಆಗಿದೆ ಸರ್ ಇಲ್ಲಿ ಬಿಡಿ ಸರ್. ಸರ್ ಇಲ್ಲಿ ಕೊಡಿ ಸರ್, ಇಲ್ಲಿ ಬನ್ನಿ ಸರ್ ಆಮೇಲೆ ಸರ್.